Yeah, please, Lordship. Malak, for listing, because I took step for against the delay application, appeal filed by me. In the matter, Baki notice also issued. The 7th of August.
Okay.
Much.
May I please be Lordship? I beg to mention two matters, Lordship. It has not been listed after 2024. One in the orders column and one in the admission column, Lordship. For 10th of August, Lordship.
Okay.
Obliged.
May I please, Lord? I beg to mention item number 48. There's some typographical error in the
Item number
48.
48.
Maybe adjourn for a week for
48 has been wrongly listed in this. It is not in the list.
it is not in the list.
Not in the list today. It will be listed. Yes.
Please, Your Lordship. Your Lordship, I beg to mention this MSc appeal for listing on next Monday, Your Lordship. In both the cases, Bakizai has been initiated, Your Lordship.
Okay.
Obliged.
May I please, Your Lordship? Lordship, I would like to beg for mentioning item number 5. I'm for the petitioner. Lordship may kindly adjourn the matter for the day and list.
You have informed the other side.
Yes, Lordship, we have.
Heard Miss D. Hajorika, the learned counsel for the appellant, who seeks an adjournment. She submits that she has informed learned counsel for the respondent regarding her prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed after 2 weeks on a date,
Lordship may kindly fix the date.
24th of August.
I beg to mention, I think 36.
Your Lordship, I am appearing for the petitioners.
36.
Yes.
My lord, in that there is IA, my lord, 1 at 7 to, I am going to file my objection today, my lord. So it may come up on some other day along with my objection.
Heard Miss.
Your-
What is your name?
M.R. Bharali. Your Lordship, enough time has been already given to the respondents to file their reply. So a short date may be.
Okay. Heard Mr. M.R. Bharali, the learned counsel for the applicant. Also heard Mr. A.K. Gupta, the learned counsel for the opposite party / respondent, who submits that he would be filing written objection in the interlocutory application during the course of the day, and as such, prays for listing this matter on some other day. The prayer is allowed. Let this matter be listed 12th of August.
Much obliged.
May I please, Your Lordship, pray for listing a one MSc appeal, Lordship, for orders.
12th August.
May I please, Your Lordship? The finisher didn't want to pursue the matter, my lord. Matter may be withdrawn.
Heard Mr. S.
A for charging.
Heard Mr. A. Bhattacharjee, learned counsel for the appellant, who submits that the appellant does not want to pursue this appeal and prays for withdrawing the same. The prayer is allowed. This appeal is dismissed on withdrawal.
I level.
May it please, Lordship. My lord, the case has a checkered background, my lord. What happened, my lord? Your Lordship granted him bail. But subsequently, my lord, another writ petition, another bail petition was filed herein suppression of material facts. So your Lordship was pleased to reject that bail. And after that, my lord, your Lordship directed that you go to the court below and file the bail petition. And accordingly, my lord, I filed the bail petition, but that was rejected. Hence this,
POCSO matter.
hence this petition is filed.
POCSO notice has to go.
Present bail petition.
Notice has to go. Heard Mr. M. A. Sheikh, the learned counsel for the petitioner. See, this application under section 483
Charge sheet will.
of BNSS has been filed by the petitioner seeking bail in connection with Session Special Case number 21/2025 arising out of Nunmati PS case number 226/2024 under section 64 read with section 64 of BNS read with section 6 of POCSO Act 2012. Stop. Let the notice be issued to the respondent number 2. The applicant, the petitioner shall take steps for issuance of notice upon the respondent number 2 in pursuant to the prevailing notification of the registry in this regard within 7 days from the date of this order, returnable on 24th of August. Let the scanned copy of the trial court record
24th of August.
be also called for, list accordingly.
Mali. Machol.
In this case, I was supposed to get the report from the IO lawsuit, but you may kindly fix it 2 lots.
Okay, 2.
Order.
Wait, please, Your Lordship. Your Lordship, we have filed the affidavit regarding dusty service upon respondent 1 and 2 on Monday, so it is not in the record, Your Lordship.
Third, Mr. S. Datta, learned counsel for the applicant, who submits that the applicant has filed affidavit in compliance regarding service of notice upon respondent number
1 and 2, Your
1
Lordship.
and 2 by dusty mode. However, same is not placed with the record and therefore requests for directing the registry to do so. Stop. Registry to place the affidavit filed by the applicant/appellant along with this record on the next date fixed. Let this matter be listed 17th of August.
May it please your lordship. My lord, as per office note dated 27/7/26, lordship, regarding respondent number 5 service, lordship, unserved notice of respondent number 5 has been received back with postal remark not under Govardhan BO, return to Borpeta Road and place at Flag A. Lordship, it's a, I think lordship, it's a wrong address, lordship. I may be allowed to take fresh steps with correct address. Otherwise, all other respondents are served, lordship,
Okay.
except 5.
Heard Miss M. Chaudhary, the learned counsel for the appellant. Also heard Mr. A. R. Agarwala, appearing for respondent number 1, 2, and 3, as well as Miss M. Kolita, appearing for respondent number 4, 7, and 8. On perusal of office note dated 27/7/2026, it appears that notice issued to respondent number 5 has returned without service. Stop. Learned counsel for the appellant prays for allowing the appellant to take fresh steps upon respondent number 5 on in the proper address. The prayer is allowed. Appellant shall do so within 7 days of the date of this order.
Lordship, may I pray for some time, lordship, because I have to collect the correct.
Within 15 days to take steps by speed post as well as by user mode, returnable on 9th of September.
Respondent, government has not deposited the 50%. We have already moved also.
Is there any stay?
Per order, 8/5/19 also.
8/5?
19.
8/5/19 in which case?
Yes, Lordship.
7/9/18, 7/9/18.
7/9/18. 7988.
In IA.
In IA
3278.
3278.
IA 3278.
3278. 18 loads. This was a requisition vehicle load sale. So the liability is shifted upon the government of Assam.
Stay was granted subject to deposit of,
50%.
50%.
they have not deposited.
Yes,
You go for execution.
Lordship, here been raised, they have given a sanction letter.
They
This
have
is the-
given? No,
It is a sanction letter only, but the deposit is not affected. Lordship.
no, if they have not deposited,
Yes, Lordship.
you go for execution.
No, Lordship.
Or whether sanction letter is sufficient for you.
No, Lordship. The thing is this, because the records has already come, so we cannot go for execution.
So what do you want?
I want that they have to make expedited the deposit.
That direction is already there.
Yes,
That
Lordship.
direction is already there. They are not complying with the direction. Therefore, you go for execution. That is the only way out.
We can go, here the Lordship records has come, so execution we cannot go in the court below Lordship. So simply, they may kindly be asked to be expected.
Yes, Ms. Kalita.
The offender instruction, whether we have sanction or not.
Now, what is this letter? Now, what is your stand?
Sanction in the year 2020.
Then why have you not deposited?
The direction was also given to the finance. With them,
Why it is not being paid?
that we need some time to get the instructions for the tracking. After 2018, for the first time, this matter has been discussed.
No, when there is a direction, that too on your prayer.
Mathematical, actually, in the detail of the instruction, that's what has happened. Whether the amount has in fact been paid over.
Okay. Continue, Kulbu. Mr. A.R. Agarwala, learned counsel for the claimant respondent submits that though by order dated 7/9/2018 passed in IA within bracket civil number 3278/2018, the respondent number the state respondent were directed to deposit 50% of the awarded amount before the registry of this court as within 6 weeks from the date of the said order. However, state has not complied with the said direction. Miss M. Kalita, the learned government council has produced a letter dated 28th October 2020 issued by the Secretary, Home and Political Department to the Government of Assam, wherein it is indicated that an amount of rupees 6,17,588 has been sanctioned by the state government in connection with MSCT case number 66/2023. She submits that since the sanction was accorded in the year 2020, some time may be granted to the state respondent to her to inform this court as to whether the said amount has been deposited or not before the motor accident claims tribunal. The prayer is allowed. Let this matter, the state government council shall intimate to this court regarding deposit or otherwise of the said amount in pursuant to the direction of this court on the next date fixed. Mr. H. Das appears for respondent number 1. You are for respondent number? Mr. Agarwal?
123, Lordship, but my land. No, day before yesterday.
Client has informed me.
Lordship, without taking my NOC, that Oklahoma should not be entertained, Lordship. Because his name should be deleted, Lordship. I am conducting the case from 2018, Lordship. And without taking NOC.
Paramedic has given me.
No, Lordship, that is different.
It's
2 years, 2 days before, Lordship, only.
No, you know the rules
Yes.
that NOC has to be obtained. There is a, you inform on the next date.
Another matter, my lord, out of the same judgment, 76 also may be taken. Out of the same judgment, 2 days case, my lord.
No, Lordship, that in that case, the amount has been,
976.
in that case, Lordship, the amount has been deposited and withdrawn by the claimant. So that is separate. Both the cases are with me, Lordship.
Let this case be listed on the next date along with MAC case number
976 obligated.
976 obligated. Regarding your appearance, you go through the rules and follow the rules.
Must oblige, Lordship.
Yes.
All party service taken twice and Kalapnama also filed by the respondent.
Respondents have appealed.
Yes, Your Honor. I am appearing for the respondent number 3 to 6.
Mm.
2 is
1, 2.
and 2 is awaited. But perhaps AD card has been returned back in respect of respondent number 2. So there is condemnation of 50 days.
50 days.
So that may be funded. Because matters is pending 2021.
19.
What is your stand?
Objection for condemnation of daily.
Heard Mr. What is your name?
Eldeka.
Heard Mr. L. Deka. This is item number?
13.
L. Deka, the learned counsel for the applicant. Also heard Mr. S. Islam, appearing for respondent number 1, as well as Mr. S. I. Akan, appearing for respondent number 3 to 6. On perusal of the office note dated in perusal of the records, it appears that the AD card issued, the AD card sent along with notice issued to respondent number 2 has returned with endorsement of the receiver thereon. As such, the notice is held to be duly served. This application under Section 5 of the Limitation Act has been filed by the applicant insurance company praying for condonation of delay of 50 days in preferring the connected appeal, whereby you are impugning what you are challenging in the appeal.
Actually,
Order dated 28/11/2020.
What is the order?
Lordship, Honorable Lanet Trial Court directed the insurance company to pay the entire amount in favor of the claimant. Lordship. That has been dismissed. And they also filed a revision petition that has been dismissed by the court below. Review petition.
Chandika. Connected appeal, stop. Where is the reason? The learned counsel for the applicant has submitted. Where are the reasons for delay?
calculation of violent application days.
Why delay has been caused?
The calculation of vacation period, that's it.
Because your lordship, they filed review petition before the Lanet court below. That also one reason they mentioned in the application, and Lanet counsel for the applicant also take some for preparing this petition. That is the reason mentioned in the.
Learned counsel for the applicant submits the reasons for delay in preferring the connected appeal has been mentioned in paragraph number 2 and 3 of
2
the
and 3.
instant interlocutory application. The learned counsel for the opposite parties do not raise any objection, have not raised any objection, considering the grounds stated in the interlocutory application. So, after going through the reasons stated in the instant interlocutory application, this court is of considered opinion that same may be regarded as sufficient reasons which prevented the present applicant in preferring the connected appeal within the prescribed period of limitation, as such, the delay of 50 days in preferring the connected appeal is hereby condoned, and this interlocutory application is allowed. Stop. Registry is to register the connected MAC appeal and list the same for admission after a week on a date to be fixed by registry. Name of Mr. S. Islam
In the appeal.
and Mr. S.I. Akan may be reflected as engaged counsel for respondent number 1 as well as respondent number 3 to 6 in the cause list henceforth.
Lordship, the respondent number 1, S. Islam.
Yes, I have mentioned that.
So deeply.
It be the was an appeal for enhancement. Has been gone, eh?
Heard Mr. What is your name?
Amsur.
Heard Mr. M. Chaudhary, learned counsel for the appellants. Also heard Ms. L. Sharma, learned counsel appearing for respondent number 1. It appears from the records that the notice issued to other respondent number 2 and 3 have been duly served, as well as the records of the MAC case number 130/2020 have also been received. Hence, this appeal is ready for hearing. List this appeal for hearing after 6 weeks on a date to be fixed by registry.
I'm of this.
May it please your lordship. Your Lordship, in this case, respondent number 1 and 2 has already entered appearance. In respect of respondent number 3 and 4, notices were waived by order dated 13/5/2026. And Your Lordship, SR has been received as per office note dated 27/7/26.
And Miss P. Goswami, P.
P.
Bhattakur, the learned counsel for the appellant. None has appeared for the respondents, though no service of notice on all respondent is complete. It also appears that records of concerned MSC case have been received. Hence, this appeal is ready for hearing. Let this appeal be listed for hearing after 4 weeks on a date to be fixed by the minister.
Obliged.
May it please your lordship. Lordship, my senior has his legs in another court. Matter may kindly time being for some time.
Lordship will find, Lordship will find it last order dated 22/5/2026, my lord.
Senior.
It is fixed for hearing.
My lord, any date, my lord.
Heard, Mr. R. Sharma, learned counsel for the appellant. Also heard Mr.
Sikolita.
C. Kolita, learned counsel for the respondent. It appears that this matter has been wrongly listed in orders column, as by on the last occasion it was directed that the same may be listed in hearing column, as the appeal is ready for hearing. As such, registry to list this matter for hearing after 4 weeks on date to be fixed by.
17, 18.
May it please your lordship. Lordship, in this case, respondent number 2 has expired. We need some time to file substitution petition, lordship.
Lordship, other legal heirs of the deceased has already been on record.
Number 2.
So 2 was the mother of the deceased. She died before argument. Completion of argument, she died on 9/4. Whereas arguments of the case were heard on 18/4/24. The wife and the children of the deceased are already on record. So brothers of the deceased may not be a necessary party because she died earlier. She is the mother of the deceased.
No, but legal heirs of the mother of the
But they will want now the brothers of the deceased.
brothers may not be regarded as,
Legal heirs. That's why I'm saying, Lordship.
may not be regarded as
Legal
dependent.
heirs. So that's why all other
No,
deceased
brothers are legal heirs of mother.
brothers may not be treated as legal heirs because children and wife was there, Lordship. And mother died prior to hearing of argument. Prior to award, she died.
Yes, what is your solution?
But lordship, award has been awarded against the mother also.
Mother also.
Yes.
So her
Some portion
her
of the
legal heir will inherit that.
No problem. They will come if let them take steps.
Heard,
I have
Miss
given the names then.
Miss M. Soikya, learned counsel for the appellant. Also heard Mr. S. K. Poddar, the learned counsel for respondent number 1, 3, 4, and 5.
Right. Lordship, one of my colleagues has filed for respondent 9 today, Lordship. Wakalatnama has been filed for respondent number 9.
It also it is submitted by learned counsel for respondent number 1, 3, and 5 that one counsel has been engaged to represent respondent number 5, respondent number 9 in this case. Has filed Vakalatnama.
Yes, today morning.
And he has filed his Vakalatnama today in the morning. Stop. Learned counsel for appellant submits that this, as respondent number 2 has expired, some time may be granted to the appellant to take appropriate steps for substituting the legal heirs of the deceased respondent. The prayer is allowed. Let this matter be listed after 4 weeks,
It na kindly. Sir.
7 September.
Obliged,
Next
sir.
item is the cross appeal lordship for enhancement. It has been registered after condonation of delay, so notice may kindly be issued.
Heard Mr. S.K. Purdas, the learned counsel for the cross object. Learned counsel for the separate appeal you have filed.
Yes, lordship, without knowing that their appeal was there. We have filed
Learned counsel
in
for the
2024.
appellants. Miss M. Soikia appears for respondent number
Lordship.
1. Let the notice be issued to the other respondents. The applicant shall the appellant shall take steps for issuance of notice within by speed post as well as by usual mode within 7 days, returnable on 7th of September.
Obliged.
Obliged, Lordship.
May I please, the Lordship?
Yes.
As for office note dated 23/7/26, neither AD card nor unserved notice has been received. May I pray, Lordship, we take steps by way of dusty mode regard to respondent number 5, Lordship.
I am appearing for respondent number 1, 2, and 1, 2, 3, and 4.
Heard Mr. D. Mujumdar, the learned counsel for the appellant. Also heard Mr. K. U. Ahmed appearing for respondent number 1 to 4. It
1, 3,
appears
and 4.
1,
2, 3, and 4.
yes, 1 to 4. 1, 2, 3, and 4. Really. It appears from office note dated 23/7/2026 that service report in respect of notice issued to respondent number 5 is awaited. Stop. The registry is directed to place the postal track consignment report of notice issued to respondent number 5 by speed post before this court on the next date fixed. The appellant is also allowed to take additional steps for issuance of notice by dusty mode within 7 days from the date of this order, returnable on 2nd September. So in the event the appellant is able to serve the notice on respondent number 5 by dusty mode, he shall file an affidavit in compliance thereto on the next date fixed, list accordingly.
Much obliged.
Yes.
May it please your lordship. As per the office note dated 15/6/2026, service report is awaited.
Your Lordship, I am representing respondent number 3, New India Assurance.
Okay. Heard Miss, what is your name?
It's Burwa lordship.
Heard Miss H. Burwa, the learned counsel for the appellant. Also heard Mr. S. Dotto, appearing for respondent number
3, Your Lordship.
3. It appears from office note dated 15/6/2026 that the service report in respect of notices issued to other respondents is awaited. The registry shall place the postal track consignment report of notice issued to respondent number 1 and 2 by speed post before this court on the next date fixed. List this matter on 17th of August.
Much obliged.
Next.
Our office note dated 22/7/2026, Lordship. respondent number duly represented. Regarding the service of respondent number 2 and 3, Lordship, AD card in respect of respondent has not returned, and regarding the usual service, Lordship, it was reported that it was unserved. Lordship, may I plead that service may be awaited since the AD has not returned, Lordship.
Okay. Heard Mr. K.K. Bhatto, the learned counsel for the appellant. Also heard Mr. J. Kolita, appearing for respondent number 1. On perusal of the office note dated 27/7/2026, it appears that notice service report in respect of notice issued to respondent number 2 and 3 by speed post is awaited. The registry is directed to place the postal track consignment report of notice issued to respondent number 2 and 3 by speed post before this court on the next date fixed. List this matter.
LCR has not also come, Lordship.
17th of August. Let also a reminder be issued for the records of the concerned motor accident claims case. Registry to take steps for issuing reminder. List accordingly.
May I please, Lordship, kindly peruse the office note dated 27/7/2026, my lord. Service complete upon respondent number 1 and 2, my lord. And 3, my lord, village headman gave with seal and signature, witnesses, entire family shifted, my lord. So we have to collect proper address of the family, my lord. Otherwise,
You are appearing for Mr.
Lordship, claimant, Lordship, respondent number 1.
Heard Miss L. Sharma, learned counsel for the applicant. Also heard Mr. J. Kolita, learned counsel for respondent number 1. On perusal of office note dated 27/7/2006, it appears that service report in respect of notices issued to respondent number 2 and 3 have returned without service, indicating that the said respondents have shifted from their earlier and place. Stop. The learned counsel for what will you do?
let the matter, the delay may be condoned, my lord, at first. My lord.
No, the notice
Notice, my lord, complete, my lord, upon respondent number 1 and 2, my lord.
3.
3, my lord, respondent is shifted with entire family, my lord. After admitting, my lord, we can take proper address, my lord, to serve the respondent, my lord.
Who is 3?
3 is driver, my lord.
How much delay is there?
118 days, my lord.
Yes, Mr. Kolita.
118 days delay.
Last की लिख ले. No, 3. 2 without. 2. 3 without service. The notice issued to respondent number 2 has returned after due service. Since the respondent number 3 is the driver of the offending vehicle, the notice to him under the circumstances that he has shifted from his earlier known address is waived. This application under Section 5 of the Limitation Act has been filed by the applicant insurance company, praying for condonation of delay of how many days?
118 days. 118 days.
118 days in preferring the connected MAC appeal. Ms. L. Sharma, learned counsel for the applicant, submits that the reasons for delay in filing the connected appeal has been stated in paragraph number
4, 5 and 6, my lord.
4, 5 and 6 of this interlocutory application. The learned counsel for the claimant respondent does not oppose the prayer for condonation of delay. Stop. After going through the grounds stated in the instant interlocutory application, this court is of considered opinion that the reasons stated therein may be regarded as sufficient cause which prevented the applicant in preferring the connected MAC appeal within the prescribed period of limitation. As such, the delay of 118 days in preferring the connected appeal is hereby condoned and this interlocutory application is allowed. The registry is directed to register the connected MAC appeal and list the same for admission after a week on a date to be fixed by it.
Lord, my name is not reflected in.
Name of Ms. L. Sharma may be reflected as engaged counsel for the appellant in the cause list henceforth. Your name is there. Name of Mr. J. Kolita may also be reflected as engaged counsel for respondent number 1 in the cause list henceforth.
I will serve my lord.
Serve.
Let it. Oh, let's go.
Please, your lordship, we have filed objections day before yesterday, still not on record.
Heard Miss B.R.A. Sultana, the learned counsel for the applicant. Also heard Mr. A. Goswami, the learned counsel for the respondent, who submits that the respondent has filed a written objection against the interlocutory application filed by the present applicant day before yesterday. However, same is not yet placed along with the record and prays for directing the registry to do so. Stop. Registry is directed to place the written objection filed by the respondent along with the record on the next date fixed. Let this matter. 17th of August.
117.
May I please your lordship? Lordship, this is an IA for condonation of delay, lordship. There has been a delay of 75 days. You may kindly condone the delay.
When the service is complete,
Lordship. Yes, lordship.
how many respondents are there?
There are five respondents
You are
and one
appearing for?
performer respondent.
Respondent number 6, lordship.
And respondent number 1 to 5?
But cause list why respondent number 5 showing 5 in my name.
Okay. Heard Mr. What is your name?
A Saranya, lordship.
A. Sarania, learned counsel for the applicant. Also heard Mr. What is your name?
B. Datta.
B. Datta,
For respondent number
appearing
6.
for respondent number 5 or 6?
6, lordship. Wrongly.
Respondent number 6. It appears from record that respondent number 1, 2, and 3 have filed their wakala. It appears from office note dated 27/2026 that respondent number 1, 2, and 3 have filed their wakalatnama. It also appears from said office note that notice issued to respondent number 4 and 5 have returned after due service. As none is representing them today, this court is proceeding ex parte against the absentee respondents.
My lord, I am on behalf of respondent number 123, my lord.
Okay. I'll cut it up lastly. Mr. B. R. Das appears for respondent number 123. You have any objection?
My lord, is it delay condon petition? I have no objection, but there is any execution petition, then any stay or petition, then I have objection. Subject
Who will
50.
tell you that what petition is this?
I is my lord delay condon petition. I have not seen, my lord.
This application under Section 5 of the Limitation Act 1963 has been preferred by the applicant Sri Shuneshwar Das, praying for condonation of delay of 75 days in preferring the connected MAC appeal. Learned counsel for the applicant submits that reasons for delay has been stated in paragraph number 3 of the instant interlocutory application. The learned counsel for the respondents have not opposed the prayer for delay, prayer for condoning delay. Stop. I have gone through the reasons stated in the instant interlocutory application. Considering the reasons to be sufficient cause which prevented the present applicant in preferring the connected MAC appeal within the prescribed period of limitation, the delay of 75 days is hereby condoned and this interlocutory application is allowed. Let the connected MAC appeal be registered and listed for admission column, listed in admission column after a week on a date to be fixed by registry.
Lordship, and the engaged counsel M. Saraniam name may be reflected in the
Name of Mr. M. Sarunia
MAC appeal. Lordship.
may be listed. It is already there. M. Sarunia may be listed as engaged counsel for the appellant in the cause list henceforth.
Lordship.
Alia, please.
Maybe so, Lordship, as per original letter, dated 23/7/2026. The services of all of the respondents are awaited, Lordship.
What is your name?
A. Islam.
Heard Mr. A. Islam, learned counsel for the appellant. Office note dated 23/7/2026 shows that notice, the service report in respect of notice issued to the respondents is abated. The registry is directed to place the postal track consignment report of notice issued to the respondents on the next date fixed. Let this matter be listed in first week of August, 5th of August.
May I proceed? I put a appeal on my lord. Respondent appear having a color number. My lord name has been shown, my lord. Service completed regarding. And TCR has been also received by the registered. The matter will be fixed for hearing measure.
Heard Mr. S. Soikia, the learned counsel for the appellant. It appears from office note dated 23/7/2026 that the sole respondent has also filed the wakalatnama. It also appears that the trial court records have also been received. Hence, this matter is ready for hearing. Let this matter be listed for hearing after 4 weeks on a date to be fixed by registry. Where is the appellant? None.
In this case, the
You
copy
are-
of IA is not served to me.
You are appearing for
Respondent number 1, 2, and 3.
and
And he's brought 4.
none has appeared for the appellant on call. Mr. A. Parvez appears for respondent number 1, 2, and 3. And Mr. D. Gogoi appears for respondent number 3. It is submitted by learned counsel for the respondents that they have not received the copy of the connected interlocutory application. The appellant is directed to furnish the same before the next date fixed, within 7 days from the date of this order. Let this matter be listed again, 2nd of September.
No, please, Lordship. Lordship, service is completed, Lordship. PCR is also received, Lordship.
Heard Mr. A. Kakoti. Appeal আছে নেকি? Appeal লিখিম। Heard Mr. M. Khan, the learned counsel for the. Who is for the appellant? Whose
Lordship,
appeal is this?
For the appellant, Lordship, and the claimant respondent have filed one cross objection.
Okay. Heard Mr. A. Kakoti, learned counsel for the appellant. Also heard Mr. M. Khan, the learned counsel appearing for respondent number
1, 2, and
1,
3.
2, and 3, as well as Mr. What is the name?
A. Alim Sheikh.
A. Alim Sheikh, appearing for respondent number 4 and 5.
Only 4 lots.
Respondent number 4. What happened to 5?
Service is complete, Lordship, but none appear from the respondent number 5. He is the driver of the vehicle, Lordship.
Where is the order regarding completion of service? Okay, okay. On perusal of the office note dated 27/7/2026, it appears that notice issued to respondent number 5 is duly served. Records of the concerned MAC case have also been received. Hence, this appeal is ready for hearing. List the same for hearing after 4 weeks on a date to be fixed by registry. In cross objection, heard Mr. M. Khan, learned counsel for the cross objector. Also heard Mr. A. Kakoti, appearing for respondent number
1.
respondent number 1,
May appear for respondent number.
as well as Mr. A. Alim Sheikh, AP. Respondent number?
4.
A. What is the name of your client? For whom you are appearing?
I am appearing for the owner lordship.
What is the name?
Field lordship, respondent number 4.
Abdul Batin Ahmed.
Respondent number 2. Stop. Let the notice be issued to respondent number 3. The cross-objector shall take steps for issuance of notice upon respondent number 3 by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks.
But in April lordship, I have not received April memo, maybe directly. That's what I provide directly.
Provide it today. I'm not reflecting it. You provide it today itself.
May I please your lordship?
My lord, in this case, I supposed to file objection in the review application, my lord, but my client, my lord, is suffering seriously. So
My lord, on
could not able to-
17/6, today till today, it's been
Now-
26 days, my lord.
On the point of law, my lord, I can argue on. Because this review petition is not maintainable.
You file objection. We are giving short date. Will you file written objection?
Lord, my client is seriously ill, so whether aging about 80 years.
So you will not be filing.
I will try, my lord, by notary from Silchar, from Phalagam.
No, you file it if you intend. We are giving some time to you.
Yes, sometime,
How much time?
at least 4 weeks time, my lord.
My lord, already they took 45 days time earlier. On that day, they short time on that ground. Earlier date also.
3rd week of August.
If my lord may fix on 12.
17 August. Heard Miss. What is your name? A.R.
A.K. Hannan, my lord.
Heard Mr. A.K. Hannan, learned counsel for the petitioner. Also heard Mr. S.K. Ghosh, learned counsel for the respondent, who submits that due to ailment of the respondent number, the written objection against the instant review application could not be filed, and he seeks some more time for filing written objection. The prayer is allowed. Let this matter be listed again on
My lord, my humble prayer is that that part may be recorded if no further time may be granted. My lord.
Let this matter be listed on 17th of August. Full stop.
Not-
Lordship, item number 26 left out, Your Honor. Lordship, I make a submission. IA copy I did not get it.
26 is
26 item.
It is not left out. Or you were not there.
Yes, absolutely. I got apology, Lordship.
What is your name?
As they.
Item number 20. Reflect the name of Mr. S. Day in as engaged counsel for respondent. The applicant is directed to furnish copy of the interlocutory application to the respondent, Baki as it is.
Obliged.
May I please be lordship? Lordship, according to office note dated 27th July 26, unserved notice of R2 and R3 says the address is not found, lordship. So we may be allowed to take fresh steps by both ways, lordship.
Heard Mr. A.R. Agarwala. So, heard Mr. A. Agarwala, learned counsel for the appellant. Office note dated
27.
7/2026 shows that the notice issued to respondent number 2 and 3 would not be served due to as the addresses cannot be located, whereas notice issued to respondent number 1 is
Awaited.
awaited.
Postal
Service
check.
report issued in respect of notice issued to respondent number 1 is awaited.
Postal checking will be.
The registry is directed to place postal track consignment report of notice issued to respondent number 1 by speed post, before this court on the next date fixed. The appellant is also directed to take fresh steps for issuance of notice upon respondent number 2 and 3 by speed post as well as by usual mode after ascertaining proper postal addresses of the aforesaid respondents
LCR received.
within 3 weeks, within a week from the date of this order, returnable on 2nd September.
Obliged.
Item 42.
May I please your lordship? As for office note dated 27/7/2026, AD card of respondent number 5 is awaited.
Third, Miss, what is the name?
P. Sharma.
P. Sharma.
Lordship, we have filed the appeal on the ground of
That the deceased was a government employee.
this is
That was the plea only that government employee knew there was no loss of income. So driver and others are not.
respondent number 5 may be strike out.
Third, Miss P. Sharma, the learned counsel for the appellant. Also heard Mr. M. Khan, appearing for the respondent number 1, 2, 3.
Yes.
What happened to 4?
Was expired, he already expired.
That would be appeal only for contact.
Learned counsel for the appellant submits that the respondent number 4 has already expired and service notice issued to respondent number 5 and service report in respect of notice issued to respondent number 5 has not arrived. She submits that considering the nature of ground taken in the instant appeal by the appellant, the presence of respondent number 4 and 5 may not be necessary. As such, she submits to waive the notice to respondent number 4 and 5. The prayer is allowed. The notice to the said respondents, respondent number 4 and 5 is accordingly waived. The records of the concerned MAC case MAC case has not yet been received. Registry to issue reminder for the same. List this matter again after 4 weeks. Date 7th of September.
On the last occasion, we sought time to file objection, my lord. The officer of the corporation was out of the station. So last chance, another 1 week or 2 weeks, an objection. Today delay confirmation.
Okay. Heard, Miss, what is your name?
D.R. Bangshari.
D.R.
Shari.
Bangshari, the learned counsel for the applicant. Also heard Mr. S. Smith, the learned counsel appearing for respondent, who prays for some more time for filing written objection against the delay condonation application. The prayer is allowed. Let this matter.
7.
Second week. 12th of August.
Item 44.
May I please, my lordship? Lordship, in this case, my lordship, there is a main miscellaneous first application and there is the interlocutory application, my lordship. Interlocutory application, there is a condonation of delay, my lordship, 262 days, my lordship. So at the motion stage, my lordship, after I file this interlocutory application, the learned just said to me that at first we have to send a notice to the respondent, private respondent, the employee. Thereafter, notice has been served to speed post, my lordship. So the latest update is that, my lordship, from the office of the district commissioner, Borpata, my lordship, a notice has to serve to me, my lordship. So I have to appear this month of 30 to pay the entire amount, my lordship, with the interest, my lordship. So my humble prayer is that until this honorable court decide the IA interlocutory application, my humble prayer before your lordship, 1 or 2 months that particular procedure may be stay or suspended until this honorable court decide at least on my IA, my lordship. If the IA disposed of or dismissed, then I have no case, my lordship. May I submit before your lordship this particular notice, my lordship? I've raised the ground in my main appeal, my lordship. And I have given the reason why it was delayed, my lordship. Particular thing was not communicated to my lordship. I have, after 5-6 months after that, I have thought that that particular judgment was rendered against me.
Heard Mr. R. Amin, the learned counsel for the applicant. On perusal of the office note dated 27/2026, it appears that the notice issued to the sole respondent has returned without due service. Without any postal remark on the envelope. Stop. The applicant is directed to take fresh steps for issuance of notice to the sole respondent within 2 days from the date of this order returned on 2nd of September. Where is the notice?
The first one is the type copy. In the inside, there is a main copy, my lordship. From the district, my lordship.
When is the next date?
My lordship.
When is the date?
Date 30 of this month, 30 July, my lordship. Next date. So my humble prayer, my lordship, until this honorable court decide on IA, let that matter be suspended or stay on the proceeding, my lordship.
Learned counsel for the applicant has submitted that in the meanwhile, the applicant has received notice to pay debt from the Office of Deputy Commissioner Borpeta and submits that unless the said notice is stayed, the purpose of filing the appeal would become infructuous. He submits that till the pendency of this interlocutory application, the execution of the notice issued to the applicant by the Notice issued to the applicant on 21/7/2026 by the certificate officer, Office of the Deputy Commissioner Borpeta may be stayed. Considering the urgency of the matter, the aforesaid notice is suspended till next returnable date. List accordingly.
Deeply obliged, my lordship.
Maybe for respondent number one.
Lordship,
Respondent number one and two are Lordship husband and wife. And they are the parents of the deceased. My lord, respondent number two has already expired. So respondent number one is the only representative. So this name may be stacked up and IA may be allowed Lordship 49 days delay.
Heard Mr. A. Kakoti, the learned counsel for the applicant. Also heard Mr. M. Khan, appearing for respondent number one, claimant. What happened to respondent number two?
Expired.
He submits that in the meanwhile, respondent number two has already expired, and therefore
Deceased was Veselov. They are the parents.
the present respondent number one is the only remaining heir of the deceased, who happens to be the mother of the deceased. This interlocutory application under Section 5 of the Limitation Act has been filed by the applicant insurance company for condoning the delay of 49 days in preparing the connected miscellaneous first appeal against judgment and order dated 16/12/2025 passed by the learned commissioner, employees compensation Bongaigaon in EC case number 12/2025. Learned counsel for the applicant has submitted that the reasons for delay in preparing the connected appeal has been stated in paragraph number
3 to 6, Lordship.
3 to 6 of the instant interlocutory application. Learned counsel for the respondent has submitted that considering the grounds stated in the instant interlocutory application, he does not have any objection to the prayer for condonation of delay. Stop. After considering the grounds stated in the instant interlocutory application to be sufficient cause which prevented the applicant insurance company from filing the connected appeal within the prescribed period of limitation, the delay of 49 days in preferring the connected appeal is hereby condoned and this interlocutory application is allowed. The registry to register the connected miscellaneous first appeal and list the same for admission after a week on a date to be fixed by. The name of Mr. M. Khan may be reflected as engaged counsel for the respondent in the cause list henceforth.
Item 47.
Lordship, in this matter, Mr. Nath is appearing. He is on legs in court number 1, Lordship. Matter may be passed over for the time being.
Okay.
Lordship, obliged.
Item 48.
Hello. The application is for withdrawal, madam. We are filing an objection for time being.
Heard Mr. A.R. Agarwal, the learned counsel for the applicant. Also heard Mr. R.K. Bhatra, the learned counsel for the opposite party / insurance company, who seeks some time for filing written objection against the prayer made by the applicant for withdrawal of the deposited amount. The prayer is allowed. Let this matter be listed 12th of August.
12th of August. Fine. My lord, in main appeal also, my lord, we need to take steps on R2 and 3, my lord.
Heard
And I
Mr.
put that
R.
it
K.
was naughty.
Bhatra. In main appeal likhebo. Heard Mr. R. K. Bhatra, learned counsel for the appellant. Also heard Mr. A. R. Agarwala, appearing for respondent number 1.
One claimant.
1 /
I
claim
received the copy of notice today itself. I'll file cross objection also.
1 / claimant. Office note dated
27/7.
no.
27/7.
No. No. Continue. Learned counsel for the appellant submits that due to some miscommunication, he could not take steps for issuance of notice upon respondent number 1 and 2, as was directed by this court.
Respondent one, I have received copy today, Lordship, and
On earlier occasion. Hence, he seeks some time for taking steps for issuance of notice upon respondent number 2 and 3. The prayer is allowed. The appellant shall take fresh steps for issuance of notice upon respondent number 2 and 3 by speed post as well as by usual mode within 7 days from the date of this order.
so I received the copy and I'll file the cross objection.
You file it because
Because I've received the copy today, so 30 days time.
yes, that will be seen from the records whether cross objection is barred by limitation or not.
No, Lordship, I received the copy today itself because there is specific order, Lordship, and it is not fit for hearing, Lordship.
Learned counsel for the appellant, learned counsel for respondent number 1 has submitted that he has received the copy of memo of appeal and notice in this appeal today only, and the respondent number 1 / claimant would be filing a cross objection in this case. Stop, list accordingly.
Like it.
12th August.
My lord, from item number 39 to 45, these 7 appeals have been filed. LA appeals have been filed by state. And in filing the same, there are some delays for which we have referred this IA for condonation of delay. This has come for the first time.
In separate delay dates.
Yes.
Period of delay.
Yes, separate.
Item number 39.
May I please?
Yes.
Lordship, I am appear for a caveator in item number 39, 42, 43, and 45.
Okay. You will be filing any objection?
Lordship, I would like to draw attention of the courts in this item, Lordship, in 39, 42, 43, and 45. That has been already been reference court awarded the amount, enhanced the amount, and that has been accepted by the PWD-RD, who has filed the appeal 1 year back, and payment has been made. It all are done out of same notification of the same village.
You have received the money.
Yes, Lordship. Not in these cases, but most of the landowners has received the money. I have the list of the cases in which they have received.
But these matters, money have not been received.
Yes, not received. But these out of the same notification of same village.
Okay.
In which the reference court has enhanced the value, and they have the PWD-RD has.
You may take this plea in your written objection.
Lordship.
Item number 39, separate orders of Asawate. Heard Mr. A. Bhattacharya, the learned counsel for the applicant. Also heard Mr. A. Deka, the learned counsel for caveator / opposite party number 1. This application What is 74 clause 1? The right to fair compensation acts. The right to fair compensation act. Two 2013. What is 74(1)? Please read.
74 is the appeal to the High Court by the.
Limitation is provided therein.
Yes, 60.
In 74(1).
Yes, yes.
Please read 74(1).
74. The requiring body or any person aggrieved by the award passed by an authority under section 69 may file an appeal to the High Court within 60 days from the date of award, provided that the High Court may, if it is satisfied that the appellant was prevented by sufficient cause.
Okay. This application under proviso to section 74 within bracket 1 of the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act 2013 has been preferred by the applicant, praying for condonation of delay of 689 days in filing the connected alia appeal. Learned counsel for the claimant submits that he would be filing his written objection against the prayer. Hence, some time may be granted. State is represented by Ms. M. Kalita. Ms. M. Kalita appears for this opposite party number 2 and 3. Let this matter be listed again on 2nd of September. Next item. For the same order, only
42, 43.
40 same order.
Right.
Delay is of 249 days. Next item.
I'm not appearing in that.
Notice will go, madam.
Notice.
Same order. No caveator. No notice will go.
Yes.
Government is represented by September. Issue notice to the respondents. Respondent number 6 and 7 is represented by Ms. M. Kalita. Against other respondents, notice will go. Clear hai? नहीं 7 September separate date दिलो. Item number 41.
$250 days.
Similar to item number 40. Delay is of 250 days. Ms. M. Kalita appears for 6 and 7. Next date 9 September.
Same day.
No. Well, separate dates.
9.
42
42.
I'm
42 is first order on Nisna Ekyahumo. 2nd September.
I mean, 43 also I have.
43 also same order.
Lots.
Same date. Forty-four without caveator जेने order होइसे. Delay is of 245 days. Next date is 9 September.
In item number 45, I have
45 first order Nisna. 2nd September. 2nd September.
44.
45.
46.
May I please, Lordship?
Lordship, there is 857 days
Heard
delay.
Mr. S. Ahmed. What is your name?
Tiyuddin.
Heard Mr. T. Uddin, learned counsel for the applicant. This application under Section 5 of the Limitation Act 1963 has been preferred by the applicant praying for condonation of delay of 857 days in preferring the connected MAC appeal. Let the notice be issued to the opposite parties. The applicant shall take steps for issuance of notice upon the opposite parties within 7 days from the date of this order, returnable on 7 September.
All the Lordship.
My lord, I'm sorry, my lord. In all these cases, my lord, the name of standing counsel PWD may be reflected for the applicant
Okay.
for our benefit.
39 to
39 to
45. The
45.
registry is directed to reflect the name of standing counsel PWD as engaged counsel for the applicants in the cause list henceforth.
Obliged.
47. Very pleased, Lordship. Lordship, in this case, I am the caveator, Lordship, but unfortunately, Lordship, the caveat without notice or serving the copy, Lordship, this case has been registered, and Lordship, registry has informed me, Lordship, that due to oversight, this
Okay,
case.
we'll issue notice, will not. This is a notice application under Section 5. We will issue notice to you. Will
Lordship, my submission is, Lordship, if I go through the Lordship, if I will receive the copy, that's because I have already filed this caveat. And
Yeah.
Lordship, then if there is no Lordship, if
Furnish
there
a
is
copy.
genuine ground, then Lordship,
furnish a copy. You have a copy now. You have a copy now.
Not right now, Lordship, during the
You
day of
will-
the course of.
During the course of the day. Will and as regards respondent number 2,
The owner of the vehicle, Lordship,
notice will go.
notice will be good.
Third, Mr. T. A. Kakoti, learned counsel for the applicant, also Mr. I. Hawk, learned counsel for the opposite party number 1/claimant. This application under Section 5 of the Limitation Act has been preferred by the applicant insurance company, praying for condonation of delay of 55 days in referring the connected miscellaneous first appeal. Issue notice. Since Mr. Hawk has appeared for his opposite party number 1, no notice need to be issued. However, the applicant is directed to furnish copy of the interlocutory application along with annexures to the learned counsel for the claimant respondent number 1 during the course of the day. As regards respondent number 2, the applicant shall take steps for issuance of notice upon said respondent within 7 days from the date of this order, returnable on 7th of September.
May it please your Lordship. Lordship, although the office note shows that Lordship, service record is not received. But Lordship, I have obtained the track consignment, Lordship, wherein it reflects that on 18/6/2026, they have received and it has been delivered to the respondent, Lordship. Can it be perused by this honorable court, my lord? My lord, to the respondent, we took service, Lordship, steps, Lordship, in 2 addresses, Lordship.
in one home address and one in office address. And regarding office address, Lordship, the respondent has received the notice of the contempt case, Lordship.
Now still we will direct the registry to place the track consignment report.
Lordship.
Heard Mr. R. Karim,
My lord.
the learned counsel for the petitioner. Office note dated 24/7/2026 shows that no, the service report in respect of notice issued to the sole respondent / contemner has been received. On the other hand, learned counsel for the petitioner submits that the notices were sent by speed post in two addresses of the contemner, one at his residential address and second one at his official address. He submits that the notice issued to the contemner at his official address has been duly delivered at the given address. And in support of his submission, he has placed on record the postal track consignment report of the notices so sent. Stop. Registry to verify the same and place and put up this record again on the next date with a proper note and also place the postal track consignment report of notices sent to sole respondent by speed post. List again on short 17th of August.
Can it be on 20, my lord?
20th of August.
Oblige, lord.
I'm taking a short break.
In this case, document peruse, order dated 23/7/2018. It was dismissed for default, and they filed a restoration petition that was allowed in 2019. And since 2018, we're not appearing in this case anymore. And the names of Mr. S.K. Goswami and 3 other counsel may be deleted from the respondent.
No, you are appearing for whom?
Mr. S.K. Goswami,
Appellant or?
respondent number 3, Your Lordship.
But S.K. Goswami is?
It was dismissed for default in the year 2018. And since then, we are not engaged in this case anymore. The name of 4 counsels may be deleted, Your Lordship, from the respondent column.
Whose name?
Mr. S.K. Goswami, R. Katkatia, P.K. Sharma, and A. Acharya. Your Lordship. And for respondent number 3, I have perused the record, Your Lordship. R.D. Wisdomdar ma'am is appearing for respondent number 3.
None has appeared for the appellant on call. Mr. S. Sharma, learned counsel appearing on behalf of Mr. S.K. Goswami, submits that they are no longer representing the respondent number 3, and as such, the names of Mr. S.K. Goswami, Mr. A. Acharya, Mr. P.K. Sharma, and Mr. P. Katkotia may not be reflected in the cause list as engaged counsel for respondent number 3. The prayer is allowed. Registry to accordingly do the needful. Place this matter again on 9th September.
Please, Your Lordship, kindly pass over the matter for timing as the senior English Regiment.
If your Lordship recalls this matter, we have preferred this appeal against an order of order of
That
status quo.
repairing.
My lord, my lord. Now they
Repairing.
have, instead of bringing some instructions so that it can be disposed of with a small order, they have filed a detailed affidavit saying that's technical plea, my lord, that it was not there mentioned in the written objection. So we have objection. We'll file a reply to this, my lord. Let me file a reply. Now that litigation will continue. And then thereafter, lordship will decide.
They have already filed.
They have already filed with a copy to us. On 28th, today's. Yesterday they filed.
Whether that is on record. That is not on record.
Maybe. We'll file a reply. We have been served with a copy. That is.
Heard Mr. D. Mojumdar, the learned senior counsel assisted by Miss S. Nath, learned counsel for the appellant. Also heard Miss D. Das, learned counsel appearing for the respondent. It is submitted by learned senior counsel that though the respondent was granted, though learned counsel for respondent was granted some time for obtaining instructions on the last date on submission of learned senior counsel for the appellant that this matter can be disposed of by allowing the appellant to repair the Assam type house in the event of any such necessity of such repairing arises. However, the respondent side has filed a detailed objection against in this appeal with a copy of the same to the appellant. Stop it. Learned senior counsel further submits that some time may be granted to the appellant so that a reply to the objection filed by the respondent may be filed by the appellant. The prayer is allowed. It also appears that the objection filed by the respondent is not tagged with the record. The registry to do so before the next date fix. Let this matter be listed. When?
Next week, 5th, it can be disposed of by
5th of August.
Matter been between two brothers. I wanted to.
Yes, it is good if they settle the issue.
There is a saying, there is no greater enemy than a brother turned foe. So this is what is happening.
Brother turned foe.
That is taking place here or somewhere.
My lord, this first appeal against order passed by the civil judge senior division to Gwalpara. Now the facts of the case is this, my lord. The plaintiff appellant filed a suit for specific performance of contract. And the defendant.
Civil Judge Gwalpara?
Yes.
Yes. Yes.
Filed a suit for specific performance of contract, in which the defendant filed written statement denying the various statements made in the plate, and they contested the suit. While the case was progressing, the learned trial court passed an order and returned the file.
In the suit?
Returned the plaint to the plaintiff on the ground that there is a SOP passed by the government of Assam that restrained the inter-religion transfer of the land. On that basis of this SOP, the learned trial court held that the suit is not untenable. because it is a inter-religion transfer. Therefore, plaintiff is returned. So we have challenged that order. Because my
Okay. Okay, we'll admit the appeal. What is Order 43 Rule 1A?
return
of plaint. Okay. Heard Mr. A.C. Sharma, the learned senior counsel, assisted by Mr. G. Bhardwaj, the learned counsel for the appellant. This appeal under Order 43 Rule 1 within bracket A of the Code of Civil Procedure 1908 has been filed by the appellant impugning the order dated 3/6/2026 passed by the Court of Learned Civil Judge Senior Division Gwalpara in title suit number 7/2024, whereby the plaint filed by the present appellant in the aforesaid title suit was returned under Order 7 Rule 10 of the Code of Civil Procedure. I have gone through the grounds stated in the memo of appeal and considered the submissions made by learned senior counsel for the appellant. This appeal is admitted. Let the notice be issued to the respondent. Let also the records of title suit number 7/2024 be called for from the trial court. Registry to take steps for requisitioning the trial court records. The appellant shall take steps for issuance of notice upon sole respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 9th of September. Yes.
May it please your lordship. My lord, the petition may be, my lord, voluminous, but then, my lord, the issue is very small, my lord, and I'll refer to only, my lord, some paragraphs of the impugned judgments, orders, and, my lord, 2-3 documents. Now, in fact, my lord, your lordship, on the first day when this matter was moved, your lordship has heard the facts at length. And, my lord, eventually the interim order was not passed because all the respondents were not represented. Now, my lord, they are all represented. And that's the reason, my lord, your lordship issued notice for consideration, my lord. Now, my lord, just to, my lord, refresh your lordship's memory, the your lordship's last order, my lord.
Yes.
Order dated. No, yes, I got. Yeah, their order, my lord, dated 23rd of June.
Yes.
Then eventually, my lord, your lordship held that if, my lord, the other.
Now, what are the facts in brief?
Facts in brief are that, my lord, there is a partnership firm where, my lord, the petitioners and the respondents, my lord, in fact, it is a, my lord, the two families. One is a Singhal family, the other is a, my lord, Jalan family. In the partnership, my lord, the single family, my lord, the petitioner number 1 has, my lord, larger share. And, my lord, what happened, my lord, the respondent number 2, Manoj Kumar Jalan, he has a, my lord, parallel similar business. My lord, the partnership firm is regarding, my lord, real estate business. And respondent number 2 has a, my lord, different, my lord, organization by which, my lord, he is also competing as a, my lord, the real estate business. And the respondent number 2 siphoned off the fund and the, my lord, resources of this partnership firm to his business, and that is where, my lord, some difference of opinion arose. Eventually, my lord, the petitioner number 1, he wrote a letter to the bank that you freeze the account. Subsequently, my lord, that was withdrawn by a second letter because of an understanding between the parties. And thereafter, my lord, there is a third communication by which the petitioner requested the bank to have, my lord, KYC procedure completed. Now, when this was done, my lord, there was also a mediation agreement. I'll refer to that, my lord. In spite of that mediation agreement settlement, the Section 9 petition was filed by the respondents asking for an injunction. And there was an ex parte injunction. We appeared, we filed our response, and thereafter the injunction was made absolute. Against that order, we had order of the Civil Judge Senior Division number 1, Gauhati. We had approached the district judge, and district judge, my lord, refused to grant stay to the order of injunction. And that is why, my lord, the petitioners are before lordship.
The appeal is pending.
Appeal is pending, my lord. Now, my lord, in my humble submission, there are 3 issues which
And
fall
in
for
the miss case 28, what happened?
28th of 13, that is, my lord, has been disposed of by, my lord, refusing the stay. Against that order.
Against that order you have
my lord.
approached.
Now, my lord, in my humble submission, my lord, there are only 3 issues that fall for consideration before your lordship. First is, my lord, whether a majority partner or even a minority partner can be totally ousted from partnership in the functioning of the partnership. That is the first issue, my lord, in view of Section 12 of the Partnership Act. That is the first issue for your lordship to consider. The second issue is that, my lord, whether there is perversity in the orders passed by the trial court and the appellate court, which requires intervention of your lordship, and whether, my lord, a 227 petition will be my lord, maintainable. These are the 3 issues for consideration, my lord. I satisfy your lordship on all these 3 points.
Yes.
Now, my lord, Partnership Act is very clear, my lord, Section 12. Yeah. Section 12, the conduct of the business. Subject to contract between the partners, every partner has a right to take part in the conduct of business. Every partner is bound to attend diligently to his duties in the conduct of the business. My lord, the sub A is, my lord, relevant. I have got a right to take, my lord, to take part in the business of the partnership. And by virtue of the, my lord, the injunction order that has been granted, which is, my lord, attained finality, my lord, I have been ousted from the partnership practically, although I am a, my lord, majority partner.
How many partners are there?
How many partners?
Are there?
My lord, partnership, did your lordship will find.
Sir, 7 partners. Page
68. There are 7 partners, my lord, page 68.
7, and the present petitioners are 2 of these out of 7.
Yes, my lord. Having the larger share. 45% of the, my lord, share.
Yes. Yes.
Now, my lord, so far the Partnership Act is concerned, my lord, I cannot be ousted unless, of course, my lord, there are certain provisions, my lord. If I act against the, my lord, interest of the partnership, then court may interfere. Now, here is a case, my lord, where the respondent number 2 has been acting against the interest of the partnership. He has got a, my lord, different business called Ambika Group, under which he is competing with the partnership firm. And also, my lord, using the resources of this, our partnership firm, to the advantage of the his Ambika Group. Now, my lord, to bring home the perversity in the orders passed by the trial court, as well as the, my lord, appellate court, my lord, may I take your lordship first to the order passed by the, my lord, the Civil Judge Senior Division, which your lordship finds at page 494. My lord, it's a very long judgment, my lord. Second volume, second volume. It starts at page 494.
Yes.
The, my lord, reasoning starts at, my lord, 566. Only one paragraph I am, my lord, pointing out to your lordship, paragraph 19. He has noted that it is evident that the instant petition is filed by the petitioner under section 9 of the Arbitration and Conciliation Act. Let us peruse section 9 of the Act prior to deciding the petition. Then, my lord, the relevant provision has been quoted. Your lordship may now kindly come to page 571.
Yes.
Page 571. The last paragraph, I'll read, my lord. In the instant case, it is evident that though the notice was issued to the opposite party number 1 on 31/1/2025, on 31st of January, my lord, a notice was issued for, my lord, commencing the arbitration by the, my lord, respondent number 2 to the petitioner number 1. And he did not respond to the said notice. The petitioner should have been approached, should have approached the High Court within 1 month after no response of the opposite party as per section 11 of the Arbitration Act. Hence, the ex party order dated 19/12/2004 ought to be vacated. This is not my submission, my lord. This is a finding of the, my lord, trial court. Since he did not, after the notice was issued to me, I did not respond. He had to, my lord, approach the High Court for appointment of arbitrator. He did not do that. And therefore, my lord, rightly, my lord, here the trial court has recorded that ex parte order dated 19/12/2004 ought to have been vacated because he did not approach under section 11 of the Arbitration Act. However, as the same is not
What
vacated.
was the ex parte order?
My lord, ex parte order was, my lord, that
What
lordship is at, my lord, is 136. 136. 136 will be in volume 1, my lord.
149 of operative portion. 114.
The operative part will be, my lord, at page 149. Paragraph 15, as your worship got it.
Interesting. Yes. Paragraph. Yes.
In accordance with the principles of justice and equity, this court finds it imperative to issue an ad interim injunction order under the following terms. An order of ad interim injunction to forthwith defreeze the current account number such and such of the petitioner number 1 firm held with the OP number 2 Indus Bank, Ganeshguri branch, and debit payment request made by concerning transactions of the said bank account prior to the date of freezing. An injunction to restrain the OP number 1 from taking any action, steps for closing, freezing of the transaction in the bank account of the petitioner number 1 firm post defreezing of the said current account of the petitioner number 1, and from taking any step from from freezing the accounts of any sister companies, subsidiaries, or parents companies firms of the petitioner. This was the, my lord, ex parte order of injunction. We filed application, my lord. Thereafter, we my lord, submitted our pleadings, and thereafter the final order was passed.
So restraint was not to take any steps for freezing any account of the petitioner's firm and sister firm.
Yes, my lord.
Not to take steps for freezing of the
Freezing
account,
any.
only that much.
My lord.
Okay.
Then, my lord, this final order comes after hearing both the parties. I was reading, my lord, 571. In the instant case, it is evident that though the notice was issued to the opposite party number 1 on 31/1/2005, and he did not respond to the said notice of the petitioner, should have been approached the High Court within 1 month after no response of the opposite party as per Section 11 of the Abolition Act. Hence, the ex parte order dated 19/12/2014 ought to be vacated. However, as the same is not vacated, he ought to have done it. Then he says, as the same is not vacated, I am of the considered opinion to dispose of the injunction petition today. Now, your lordship may come to, my lord, page 573, paragraph 24, because, my lord, here the bank was playing a very dubious role. Initially, my lord, on my request, the account was freezed. Thereafter, on my request again, my lord, it was defreezed. And thereafter, I requested the bank that you have not done the KYC for a very long time. You do it because under the Banking Regulation Act and the, my lord, notifications of the RBI, you have to do it, you do it. That has not been done, my lord. The bank is hand in glove with the respondent number 2. Now, paragraph 24, I am reading. Now, prior to decide the 3 golden principles of injunction, let us summarize the contention of the opposite party number 2 and 3. They have stated that the bank has acted impartially, bona fide, and strictly in accordance with banking norms and regulatory requirements. It has no role in the inter-se dispute between the parties and shall abide by any direction issued by the court. Now, my lord, that this stand is, my lord, not what they have subsequently stated in their affidavit. That, my lord, I'll take your lordship to a little later. Now, your lordship may come to, my lord, the ultimate finding at page 592, that is the, my lord, direction given. 592, paragraph 25.
Yes.
Hence, I am of the considered opinion that all the 3 golden principles are in favor of the petitioners at this stage. Hence, the instant petition is disposed of with the following directions till constitution of arbitral tribunal. No time has been given, my lord. An interim injunction restraining the opposite party number 2 not to freeze the current account number such and such of the petitioner number 1 firm held in IndusInd Bank, Ganeshguri branch, and honor all debit payment requests made by the concerning transactions of the said bank account prior to date of freezing till constitution of arbitral tribunal. Then this part, my lord, an interim injunction restraining the opposite party number 1 firm from interfering with the day-to-day affairs of the petitioner number 1 firm and its sister firms concerned.
What is the opposite party number 1 firm?
Opposite party number 1 firm is, my lord, the Pride Realty. That is the, my respondent number 1 hearing. And its sister firms. Sister firms are many. And not specified.
No, who was restrained?
My lord.
The opposite party number 1 firm was restrained.
My lord, no, the petitioner has been restrained.
But the language says that.
An interim is restraining the opposite party number 1 firm. Yes, my lord.
So firm was restrained.
Restrained. That is, your lordship is correct, my lord. In fact, my lord, it ought to have been perhaps opposite party number 1. That is how we have understood and everyone has understood, my lord. Because my lord, firm cannot itself, my lord, restrain itself.
Who was opposite party number 1?
I was my lord, opposite party number 1.
No, I means you are 2 here.
Oh, my lord, the opposite party number 1 and 2. My lord, the petition number 1 here.
No, in misarbitration case 205. Who was the opposite party number 1? Where is the application?
Page 104. Page 101 it begins.
104.
It's location and single.
Location and is the my lord. Who is the petitioner number 1 here? He was the my lord OP number 1
So
there.
only the petitioner number 1 was restrained. The mentioning of the word firm is wrong.
Wrong, man. That is wrong. Absolutely. Your lordship is absolutely correct.
Okay. Yes.
Very good, yeah. 9.2%. My lord, for a brief moment, may I take your lordship to the my lord provision of section 9.2 of the my lord arbitration and conciliation act.
Yes.
May I read my lord
Yes.
subsection 2, where before the commencement of the arbitral proceeding, a court passes an order for any interim measure of protection under subsection 1, the arbitral proceeding shall be commenced within a period of 90 days from the date of such order or within such further time as the court may determine. And my lord, subsection 1 also, my lord, makes it clear that, my lord, the properties have to be protected. Now, within 90 days, the proceeding has to commence.
Arbitral proceeding.
Arbitral proceeding. He issued a notice in January, my lord. I did not respond. So, natural, my lord, course would have been to approach the, my lord, the High Court for appointment of arbitrator. That has not been done. And therefore, my lord, now, my lord, this will have a bearing with the, my lord, settlement agreement between the parties. There is a settlement agreement.
Page 90.
Your lordship will get it at page 90. Section page 90, na?
Page 90.
That is very important, my lord. That has been brought on record, and this was completely ignored.
Page what? Page number?
Page 90. The mediation provision to made. May I read it, my lord?
Yes.
These are the only few documents I'd like to, my lord, present before your lordship. Today, 23rd September 2014, in a meeting attended by Mr. Manoj Jalan, son of so-and-so, in presence of Aditya Parasarnka as a mediator with representatives of Indumati Singh and family, the following has been decided that number 1 is Dharapur project under Air City Private Limited will be given to single family. Number 2, Uzanbazar project about 2 bighas protect Sunanda Lokesh Enterprise and Projects which is development agreement dated 2337 letters, land available for project is 20 bighas, 3 letters. Hence, the remaining land has not been considered in valuation. Then 3 is very important, Mike. The Protect Pride, a partnership farm, will be 100% given to Manoj Jalan and family. Then 4, properties at Protect Center and rental properties of Sangsari, wherein the warehouse of 3 numbers are already constructed and construction will be completed for finally being offered for rental purpose, will go to single family. Warehouse at Bongara and so property will entirely go to Manoj Jalan family. Office and other infrastructure will go to single family. So this is a, my lord, agreement which has been signed by both all the parties, my lord. And in this context, may I draw your lordship attention to the, my lord, Mediation Act. Mediation Act 2023. Yeah.
Yes.
May I, my lord, turn your lordship attention to section 27 at page 14.
Yes.
Enforcement of mediated settlement agreement. A mediated settlement agreement resulting from a mediation signed by the parties and authenticated by the mediator shall be final and binding on the parties and persons claiming under them respectively and enforceable as per provisions of subsection 2. Subsection 2, my lord, subject to the provisions of section 28, the mediated settlement agreement shall be enforced in accordance with the provisions of Code of Civil Procedure 1905 in the same manner as if it were a judgment or decree passed by the court, and may accordingly be relied on by any of the parties or persons claiming through them by way of defense, set off, or otherwise in any legal proceeding. Then, my lord, section 28 will also be relevant. Challenge to mediated settlement agreement. Notwithstanding anything contained in any other law for the time being in force, in any case in which the mediated settlement agreement is arrived at between the parties and is sought to be challenged by either of the parties, such party may file an application before the court or tribunal of competent jurisdiction. A mediated settlement agreement may be challenged only on all or any of the following grounds. Number A, fraud. Number 2, corruption. Number 3, impersonation, where the mediation was conducted in disputed or matters not fit for mediation under section 6. Then 3 is important. An application for challenging the mediated settlement agreement shall not be made after 90 days have elapsed from the date on which the party making the application has received a copy of the mediated settlement agreement under subsection 3 of section 19. So, my lord, that period has long expired. And this mediated settlement, my lord, has neither been, my lord, denied by them, nor, my lord, they have made any challenge to that. Now, my lord, your lordship has seen the, my lord, the mediated settlement agreement.
What is a mediated settlement agreement?
This is the agreement, my lord, page
No,
90.
What is the definition under this Mediation Act?
Mediation agreement is, my lord, at section 4 of the Mediation Act. A mediation agreement shall be in writing by or between the parties and anyone claiming to them or submit to the mediation or certain disputes which have arisen on which or which may arise in between the parties. A mediation agreement may be in the form of a mediation clause in a contract or in the form of a separate agreement. A mediation agreement is in
No,
writing if it is
not
contained.
mediation agreement,
My lord,
mediated settlement agreement.
my lord.
There is a difference between mediation or agreement and mediated settlement agreement.
My lord, this is a mediated settlement, my lord.
Now, is it a mediation agreement or mediated settlement agreement?
It is a mediated settlement, my lord.
So mediated settlement agreement has been defined in section 19.
Section 19 says, my lord, a mediated settlement agreement includes an agreement in writing between some of all or all the parties resulting from mediation, settling or some or all of the disputes between such parties and authenticated by a mediator, provided that the terms of the mediated settlement agreement may extend beyond the disputes referred to mediation. And my lord, this, your lordship, will have to consider read with section 61 of the Arbitration and Conciliation Act. Your lordship will kindly take note of the fact that, my lord, this mediated settlement has neither been disputed by them nor this has been challenged by them.
Now, is it a mediated settlement agreement or a family settlement? Family arrangement?
Because, my lord, the mediator is there, his name has been reflected. In presence of Aditya Parasramuka as a mediator. So it's a mediated settlement. They have not come up with any, my lord, plea that this is not a mediated settlement.
No, I want to understand.
My lord.
Whether for a mediation any reference is required or reference to a mediator
By the court.
or by the court or
My
so.
lord, pre-litigation mediation is, my lord, allowed for that, my lord. No order from the court is, my lord, required. Even in, my lord, the divorce proceedings or any other issues.
So your submission is that this is a mediated settlement agreement which is to be executed like a decree of a civil court.
My lord. After, my lord, after these conditions are fulfilled, my lord, that within 90 days it is challenged.
Okay.
Then your lordship may kindly come to, my lord,
This has
section 61 of the Arbitration and Conciliation Act. Section 61, my lord, the reference of conciliation in enactments.
Yes.
Any provision in any other enactment for the time being in force, providing for resolution of disputes through conciliation in accordance with the provisions of this act shall be construed as a reference to mediation as provided under the Mediation Act 2023. Conciliation as provided under this act and the Code of Civil Procedure shall be construed as mediation referred to in clause H of section 3 of the Mediation Act.
So what you want to say?
My submission before lordship is that, my lord, the party is having, my lord, agreed to division of the, my lord, properties by this mediated settlement, my lord, they ought to have honored it. In fact, my lord, the subject matter of the section 9 petition is, my lord, the price reality group, where I am the, my lord, we are the majority partner. And, my lord, this settles the, my lord, issues between the parties. Only problem is that, my lord, they have not honored it. Your lordship has seen, my lord,
No, but Pride Realty Group,
my lord.
that is the, it was given to the,
My lord, Jalan family.
other side.
My lord.
100% was given to other.
Yes, my lord. In spite of that, my lord, what are the other, my lord, clauses say, that has not been left to us. And my lord, I have been restrained from functioning in the partnership. That is where the grievance is, my lord. Your lordship will also take note of the fact that, my lord, this mediated settlement agreement has not been denied by them. They have not taken any plea that this is not a mediated settlement. Nowhere.
Okay.
Now,
How to enforce it?
my lord, enforcing this will entail some other things also, my lord. That's why a suit has been filed for enforcement of this. Now, my lord,
You have filed a suit
Yes, my lord.
for execution of this.
Not execution, actually, we have filed a title suit, my lord, because there are other relief. They have not, my lord, honored this agreement. They have
No,
taken their part.
Suppose, as per Mediation Act, it is to be treated as a decree of a civil court. How to get it enforced?
My lord, it can be executed by filing an execution petition. But when there are, my lord, other things necessary, my lord, in addition to the, my lord, execution of this agreement alone, my lord, then, my lord, there is no alternative but to file a suit. And that is what the, my lord.
And you have filed a suit. Have you filed a suit?
I have filed a suit.
Which one?
That, my lord, of course, in the pleadings, I think it is there in the pleading. I'll show, my lord.
Okay.
Now, my lord, this document has been totally suppressed in the Section 9 petition. They are guilty of, my lord, suppression of facts and obtaining an order by misleading the, my lord, trial.
Yes.
In fact, this document was brought on record by us before the, my lord, trial court by an affidavit. And that has not been denied by them.
Okay.
In view of the, my lord, existence of this settlement, my lord, the trial court could not have passed the order. And more so, my lord, since, my lord, I am also protected by Section 12 of the Partnership Act. And the district judge also, my lord, ignored these aspects totally and went on to discuss the, my lord, balance of convenience by ousting me totally from my partnership firm. If your lordship comes to the order passed by the district judge, that your lordship will get at page 742. My lord, if I may, my lord, just interpret in the window. The title suit number is, my lord,
Yes.
266 of 2025 in the Court of Civil Judge, Senior Division, number 1 at Gauhati.
What relief you are seeking in that suit?
My lord.
What relief you have sought?
My lord, relief sought is, my lord, decree that Jalan and my lord, they are bound to act as per the terms and conditions of the mediated settlement agreement. Mediated settlement agreement dated 23/9/2024, and for the bank to accept the plaintiff as partner and not to allow Manoj Jalan to single-handedly operate the bank accounts. Right? Okay. These are the relief, my lord, we sought. That is pending.
So part of the relief is similar to What you have sought in the.
Yes, my lord, here I have come before your lordship, my lord, for two reasons. Firstly, my lord, the order passed by the, my lord, a civil judge senior division is, my lord, perverse. In the sense that, my lord, he himself having held that the order ought to have been vacated. Thereafter, my lord, he goes on for deciding the matter, totally ignoring this, my lord, settlement. And, my lord, ousting me from the partnership completely. And the, my lord, district judge, your lordship will find his reasonings, my lord, very strange. Relying on a decision, he has taken note of the fact that the respondent number 2 is having a, my lord, competitive competition firm competing with this partnership, and to the detriment of the interest of my partnership, that has been taken note of. Your lordship may come to, my lord, paragraph page 752. The operative part, my lord, the reasoning starts there, paragraph 10.
Yes.
I have deeply considered the submissions made by the learned counsel of the petitioner stating that the opposite party is running a parallel owned real estate business under the brand name Ambika Group and has siphoned more than 35 crores from Protect Group to his own Ambika Group. The submission requires proper hearing between the parties and can be decided only on merit after hearing both the sides. It is found that the submission of the learned counsel for the petitioners are mostly on the merit of the appeal. Then, my lord, the learned counsel for the purpose of grant of stay has relied on the case law of Moolchand Yadav versus Raja Buland Sugar Company Limited. In that case, Moolchand Yadav was occupying one room in an office of the corporation, namely Hari Bhavan. There was a decree against Moolchand Yadav for vacating the room against which Moolchand Yadav has preferred an appeal. In that case, the Honorable Supreme Court observed that Moolchand Yadav has been directed to vacate the room and hand over possession to the respondent. The Honorable Supreme Court observed that if orders are challenged and the appeals are pending, one cannot permit a swinging pendulum continuously taking place during pendency of the appeal. It is observed that judicial approach requires that during pendency of the appeal, the operation of an order having serious civil consequences must be suspended. Accordingly, the Honorable Supreme Court allowed the petition filed by Moolchand Yadav for stay of the order passed by the court below. The basic point in Moolchand Yadav judgment is that there must be serious civil consequences for granting stay. Now, what is the consequence here, my lord? I am ousted from the partnership. Is it not a, my lord, serious consequence, civil consequence? Then your lordship may skip and come to page 758. Paragraph 17.
Yes. Yes.
A careful perusal of the above observation made by the Honorable Supreme Court and the Honorable High Court reflects that interim order passed by the trial court after hearing both the sides cannot be stayed by appellate court by exercising discretionary power under Order 41 Rule 5 of the CPC, unless it is found that the trial court passed the order arbitrarily or perversely. My lord, I have already shown, my lord, how the order of the trial court is perverse. But the appellate court comes to a finding thereafter, my lord. Paragraph 18. A careful perusal of the impugned order dated 17/2/2026 reflects that the learned trial court in misarbitration case number 205 of 2024 has granted interim injunction restraining the opposite party number 2 from freezing the account of the petitioner number 1 firm held in Industrial Bank and honor all debit payment requests made by concerning transactions of the said bank account prior to the date of freezing till constitution of arbitral tribunal, and also passed an interim injunction restraining the opposite party number 1 firm from interfering with the day-to-day affair of the petitioner number 1 firm and its sister concerns, and further restrained from taking any action from freezing the accounts of the petitioner number 1 firm and any of the sister concerns. Perusal of the impugned order reflects that the order passed by the learned trial court in the arbitration case was interim in nature, and on careful perusal of the impugned order reflects that the said order is not stayed, will not have any serious civil consequences. My lord, the trial court has finally decided the injunction matter without, my lord, giving any time limit and that will continue. And the arbitral proceeding, my lord, there is no serious.
Now, whether the arbitrator has been appointed.
No, my lord, they have not approached the High Court for appointment of arbitrator. They are sitting tight. They have got an injunction order.
They have sought for adjournments and appeal.
Fortunately. They have filed. Now they have filed. But then, my lord, the time has perhaps, my lord, passed by. Now, what is the serious civil consequence, my lord? Ousting me from my partnership firm, where I am a, my lord, larger shareholder, and it doesn't have any serious consequences. I fail to understand, my lord, this reasoning. My lord, so far as the appeal is concerned, there, my lord, the issue is to be decided whether Section 9 petition will still survive or not. These are issues that I am not, my lord, imploring your lordship to examine this matter. My prayer is very limited, my lord, that I should be allowed to, my lord, participate in the partnership firm, that I should be allowed to be joint account holder. I mean, jointly allowed to operate, my lord, the bank accounts. That is the limited prayer I have. And I have shown, my lord, how the orders are perverse. And if there is perversity, my lord, I'll show the Supreme Court decisions where your lordship would like, your lordship will be pleased to, my lord, interfere in the matter. I'll refer to, my lord, to Supreme Court cases on that.
Okay, we'll continue at 2.
Petition based on this, and 93.56 of the quoted here. The section of petition itself is not maintained.
For reasons mentioned in the judgment, this appeal is allowed and the compensation awarded to the appellant is enhanced to 11,05,000 rupees with 7.5% interest. Let me record. First one.
Sir, I am appearing partially, Lord, sir.
For reasons mentioned in the judgment, both the appeals as well as cross objections are partly allowed. The compensation is enhanced to 11,97,482 with 7.5% per interest at the rate of 7.5% per annum. No interest is awarded to the addition made on account of future prospect.
Obliged. Deeply obliged.
The record the third.
My lord, I was completing my judgment. Only 2-3 points, my lord. Couple of points I would like to place before your lordship. Your lordship has taken note of the fact that, my lord, an application for appointment of arbitrator has been filed by the, my lord, respondent number 2. 2 dates should be relevant, my lord. Before the, my lord, civil judge senior division, the final hearing took place on 29/1/2026. Final hearing on the injunction matter. And on that day, the order was reserved. 29th of January 2026.
Yes.
And the order was reserved. And the Section 11 application was filed on 5/2/2026.
Yes.
Now, by virtue of the, my lord, interim order and the, my lord, subsequent order making the interim order absolute, the respondent number 2 is making profit, my lord. And both the, my lord, trial court and the appellate court did not consider the fact. Firstly, my lord, as I have said, that period of, my lord, 90 days And my lord, section 16 and section 12 of the my lord Partnership Act, because my lord, by virtue of the orders, he has been my lord running the business. Therefore, there ought to have been an order at least
What is there in section 16?
Regarding my lord personal profits earned by partners. Before that, your worship may come to section 12. Section 12 is of the Partnership Act.
But that is only an allegation that he is deviating funds for this Ambika group. That is the allegation made by you.
No,
It
that
has
is
not.
denied, my lord. That he has got, my lord, a different competing, my
No,
lord.
that is not denied,
My
but you have alleged that he is siphoning a fund and putting it in that
Yes, my lord.
concern.
And not
the-
only the,
the-
my lord, the fund, the human resource also, my lord, the materials, that, my lord, I have a list. So, my lord, when
And the first appellate court has observed that that matter will be decided in the appeal. That is still an allegation.
Yes, my lord. Now, what I am submitting before lordship is that so far as this application before lordship is concerned, my lord, whether the section 9 petition is maintainable or not, your lordship need not go presently, my lord. That will be a subject matter to be decided by the appellate court. The only thing, my lord, that I am urging before your lordship that I cannot be ousted totally from the partnership.
Yes.
And I must have my say, and therefore, my lord, we should jointly, my lord, function, my lord, manage the partnership. When, my lord, there is a competitive entity run by you, my lord, exclusively to the detriment of the partnership firm, whether the court ought to have, my lord, ousted me totally from the, my lord, partnership. Now, my lord, so far as that, my lord, mediation settlement is concerned,
Whether in this section 9 petition filed before the trial court, this relief was prayed for by the other side
my lord,
to
the
oust you from.
the prayer your worship will see, my lord, in the application under section 9.
Where is the prayer?
It starts at page 101.
Ends at 152.
133 is the prayer, my lord.
130. Page number 130.
133. No.
No. 133
I'm sorry,
something.
the page number. Page 123, 122, my lord. One 122, the prayers. Prayer number 1.
Defreezing.
To forthwith defreeze the current account number such and such of the petitioner number 1 from.
Second.
Held with the OP number 2, bank. Then prayer number 2, restraining OP from interfering with the day-to-day affairs of and management of the petitioner number 1 firm and that of its sister concerns. 3, restraining the opposite party from taking any action steps for freezing of the transactions. These are the, my lord, prayers made. And prayer 4 is, my lord, restraining the opposite party number 1 from generally acting against the interests of the petitioner number 1 firm or its sister companies. So these are the prayers.
Okay.
Now, my lord, so far as that mediation settlement is concerned, my lord, although I have shown, my lord, under section 27 and 28, that is it been finally, irrespective of existence of that, my lord, because that is a question, my lord, whether because of that, my lord, settlement, whether the section 9 petition will survive or not, that is a matter to be decided by the, my lord, appellate court.
Yes.
And the the ground on which and the, my lord, cause of action for which the Section 9 petition was filed was a letter issued by the petitioner to the bank at page 93. Your lordship will kindly peruse that, my lord. And that has been, my lord, twisted in such a manner as if, my lord, I have asked to defreeze the accounts. Page 93.
Yes.
It's a communication to the bank. Now, your lordship may skip the first page, my lord. Your lordship may come to page 94, the request made to the bank. Page 94, last paragraph. I request you to order for a review and audit of the signatories KYC to be redone of all the bank accounts to reassign the check signing authority with all respective partners in partnership firm as per the partnership agreement and directors of the companies. And once you see that not all signatories are on the same page, it will reveal as to what is going on. You can then please freeze the respective bank accounts until further investigation. Now, this is a requirement, a statutory requirement to be complied with by the bank. And for 1.5 years, my lord, that has not been done. And my lord, when I write this letter, they could realize, the respondents could realize that if this KYC is done, then the problem will arise. That is how the Section 9 petition came to be filed. If your lordship kindly comes to page 97, my lord, this is the, my lord, communication of the bank, my lord. It's stand, because I said, my lord, I submitted before lordship that I'll come to the, my lord, the functioning of the department, how they are hand in glove. The bank now says, my lord, in all accounts he'll operate. Your lordship will kindly read page 97. This has been written by the bank to the petitioner number 1. Reply to your letter dated so and so. Address to Industrial Bank. Dear sir, we Industrial Bank Limited is a scheduled commercial bank registered under the Banking Regulation Act and has a long-standing history of reputation in reliable and depending banking institution providing various financial and banking services to its customers. It has pioneered initiatives that have been so and so, so and so. Then next paragraph. As per bank record, you are authorized signatory or partner in the following accounts of the Protect Group companies and partnership firm. Only one, my lord. Pride Realty, I am so shown as a partner. Next page, second paragraph, your lordship will read. However, for the accounts mentioned in serial number 2, 3, 4, 5, as the said accounts were opened under RERA regulation, debit freeze cannot be marked without court order. With respect to the other accounts of the Protect Group's companies and partnership firms, as per bank's record, you are neither authorized signatory nor a partner in the respective accounts of the Protect Group's companies and partnership firms, and hence you are requested for making debit free. Marking debit freeze in the said accounts cannot be acceded to. Now, if your lordship kindly comes to page 84.
Same account, same bank.
The same bank, my lord, the earlier letter at page 98 is 13/12/2024, and the letter on 16/5/2024, earlier, my lord, what they say. In 6 months, my lord, they have changed their stand. This letter is addressed by the bank to me. The bank, in receipt of the instructions that is so and so regarding the restricting operations in the accounts of Protect Group companies and partnership accounts, please refer to the following details action taken by the bank. First, Protect Bilcon Private Limited, account number such and such, mark debit freeze as you are being the authorized signatory. Then, my lord, the second account, no action taken as you are not the authorized signatory. Then Protect Realtors Private Limited, no action taken as you are not the authorized signatory. Please provide order from the police authority, court order for marking freeze account. Then Aero City Building, no action. Then Protect Realty, they said, marked as you being one of the partners in the firm. Then protect planters, you being one of the partners in the firm. Protect grant, being you are one of the partners of the firm. Locus Enterprises, one of the partner of the firm. Protect housing, you are one of the partners of the firm. And Pride Realty, being the one of the partners in the firm. This is a communication of 16/5/2024, and in December, my lord, they take a different stand saying that I am partner only in respect of Pride Realty. And that is the reason why I asked them that you follow the KYC norms. So it is mandatory. You have to do it. They don't do it. And there is no explanation why they have not done it. That is why I submit, my lord, the respondent number 2 and the bank, they are in hand in glove. And their action is, my lord, liable to be interfered with. Now this letter, page 93, they say that I have requested for freezing the account. If your lordship kindly comes to page 329, that stand will be, my lord, nullified. Page 329. I have, my lord, given an undertaking before this court, before the, my lord, civil judge, that paragraph 2 at page 330, that the applicant number 1 undertakes to process and clear all debit instruments, withdrawals, and give consent to such decision with respect to partnership firms, companies, all entities and sister concerns, after understanding the genuineness of the payment matter and after thorough examination of the same with established procedure. So that undertaking I have given before the, my lord, trial court.
Which para?
My lord.
Page 330.
329. Relevant paragraph is at page, my lord, 330.
330.
My lord.
Which para?
Paragraph number 2.
Okay.
So the apprehension that, my lord, I have asked the bank to freeze all the accounts, my lord, that is not true, and an undertaking has been given, my lord. Your lordship has already seen the communication that I have issued, only, my lord, requesting fulfillment of KYC norms. Because, my lord, if the KYC norms are, my lord, executed, gone through, my lord, then the 2 different stand taken by the bank within the period of 6 months, that will follow through. Now, my lord, perhaps I have to, my lord, satisfy your lordship, my lord, why 227, my lord?
Yes.
Why 227? Whether, my lord, 227 petition, your lordship will, my lord, interfere or not?
Yes.
On that, my lord, I will rely on 2 decisions of the Honorable Supreme Court, more branch to go to May I, my lord, supply the judgments?
Oh,
On 227.
that is on 1990, section 922.
For the banks to open. Maybe the easier for you. My lord, there is a chain of judgments. It all started in 1999, my lord, from Sundaram Finance.
No.
1999, volume 2, SCC 479. I'll read only one paragraph, my lord. The issue there was limited, but then, my lord, taking cue from this, my lord, and relying on this judgment, there are two judgments which will be, my lord, applicable in our case. Paragraph 19, may I read, my lord?
Yes.
When a party applies under Section 9 of the 1996 Act, it is implicit that it accepts that there is a final and binding arbitration agreement in existence. It is also implicit that a dispute must have arisen which is referable to arbitral tribunal. Section 9 further contemplates arbitration proceeding taking place between the parties. Mr. Subramaniam is therefore right in submitting that when an application under Section 9 is filed before the commencement of the arbitral proceeding, there has to be manifest intention on the part of the applicant to take recourse to arbitral proceedings. That, my lord, I have already pointed out. They did not have, my lord, genuine interest. There has to be manifest intention on the part of the applicant to take recourse to arbitral proceedings if at the time when the application under Section 9 is filed, the proceedings have not yet not commenced under Section 21 of the 1996 Act. In order to give full effect to the words before or during arbitral proceedings occurring Section 9, it would not be necessary that a notice invoking the arbitration clause must be issued to the opposite party before an application under Section 19 can be filed. The issuance of a notice may, in a given case, be sufficient to establish the manifest intention to have the dispute referred to arbitral tribunal. But a situation may also demand that a party may choose to apply under Section 9 for an interim measure even before issuing a notice contemplated by Section 21 of the said Act. If an application is so made, the court will first have to be satisfied that there exists a valid arbitration agreement and the applicant intends to take the dispute to arbitration. Once it is so satisfied, the court will have the jurisdiction to pass orders under Section 9, giving such interim protection as the facts and circumstances warrant. While passing such an order, and in order to ensure that effective steps are taken to commence the arbitral proceeding, the court, while exercising jurisdiction under Section 9, can pass a conditional order to put the applicant to such terms as it may deem fit with a view to see that effective steps are taken by the applicant for commencing the arbitral proceedings. What is apparent, however, is that the court is not debarred from dealing with an application under Section 9 merely because no notice has been issued. Now, my lord, this part that my lord, the conditional order has to be passed, limited to that period, my lord, that is missing. Now, my lord, this order has been passed by the High Court, my lord, under Article 227. And finally, my lord, the Supreme Court has. Then, my lord, this was relied on, and on the basis of that, my lord, the other decision, my lord, 2004 volume 3 SSC 155, that is Farm Osok Traders. There, my lord, I'll refer to only two paragraphs, my lord. Paragraph 18, paragraph 18 will suffice perhaps. Has your lordship got it now?
17, sir. 17,
Your lordship will take up from 17, my lord, section 7, my lord, paragraph 17. There are two other factors which are weighing heavily with us, which we proceed to record. As per the law laid down by this court in Sundaram Finance Limited, your lordship has just seen, an application under Section 9 seeking interim relief is maintainable even before commencement of the arbitral proceeding. What does that mean? In Sundaram Finance Limited itself, the court has said, it is true that when an application under Section 9 is filed before the commencement of the arbitral proceeding, there has to be manifest intention on the part of the applicant to take recourse to the arbitral proceedings. Section 9 permits application being filed in the court before the commencement of the arbitral proceeding, but the provision does not give any indication as of how much before. The word before means inter alia, ahead of, in presence of, sight or sight of, under the consideration or cognizance of. The two events sought to be interconnected by the use of the term before must have proximity of relationship by reference to occurrence, the later event proximately following the proceeding, even as foreseeable or within certainty. The party invoking section 9 may not have actually commenced the arbitral proceeding, but must be able to satisfy the court that the arbitral proceedings are actually contemplated or manifestly intended, as Sundaram Finance Limited puts it, and are positively going to commence within a reasonable time. What is a reasonable time will depend on the facts and circumstances of each case, and the nature of interim relief sought for would itself give an indication thereof. The distance of time must not be such as would destroy the proximity of relationship of the two events between which it exists and elapses. The purpose of enacting section 9, read in the light of the model in ancestral rules, is to provide interim measures of protection. The order passed by the court should fall within the meaning of the expression an interim measure of protection as distinguished from an all-time permanent protection. Your Lordship has seen, my lord, the trial court has given an all-time permanent protection till arbitral proceeding. Then 18, under the ANC Act 1996, unlike the predecessor Act of 1940, the arbitral tribunal is empowered by section 17 of the Act to make orders amounting to interim measures. The need for section 9, in spite of section 17 having been enacted, is that section 17 would operate only during the existence of arbitral tribunal and its being functional. During that period, the power conferred on arbitral tribunal under section 17 and the power conferred on the court under section 9 may overlap to some extent, but so far as the period of pre and post arbitral proceeding is concerned, the party requiring an interim measure of protection shall have to approach only the court. The party having succeeded in securing an interim measure of protection before arbitral proceedings cannot afford to sit and sleep over the relief, conveniently forgetting the proximately contemplated or manifestly intended arbitral proceedings itself. If arbitral proceedings are not commenced within a reasonable time of an order under section 9, the relationship between order under section 9 and the arbitral proceeding would stand snapped, and this is what is important, my lord, would stand snapped, and the relief allowed to the party shall cease to be an order made before, that is, in contemplation of arbitral proceeding. The court approached by a party with an application under section 9 is justified in asking the party and being told how and when the party approaching the court proposes to commence the arbitral proceeding. Rather, the scheme in which section 9 is placed obliges the court to do so. The court may also, while passing an order under section 9, put the party on terms and may recall the order if the party commits breach of the terms. Your Lordship has already taken note of the fact that, my lord, the trial court has said that the order ought to have been vacated. Thereafter, my lord, he goes on making the interim order absolute. Now, my lord, another decision I'd like to place, my lord, your Lordship will kindly bear with me only for a few minutes, my lord. Regenda Hotels, 2026, Volume 4, SCC 142.
Yes.
Now, my lord, here it has been decided what happens if notice not served for arbitration at interim stay, my lord, gets vacated. Now, your Lordship may kindly come to paragraph 34. Paragraph 34 at page 155.
Yes.
The rationale underlying section 9(2) of the Act is that the arbitral proceedings shall be commenced within 90 days from the grant of interim protection. This prevents a party from abusing section 9 to obtain interim protection without submitting to arbitral forum, and it also ensures that the interim measures remain tied to the arbitration they are meant to support. If this safeguard is interpreted in a manner that contradicts the statutory definition of commencement, to do so would allow courts to rewrite section 21 sub silentio. Then 35, if
the commencement is to be construed from the date of filing of the petition under section 11 of the Act, the statutory scheme insisting on expedition of in commencement arbitration proceeding after the grant of interim protection under section 9 would be rendered incoherent. The applicant could have notice under section 21 but still be held non-compliant until a section 11 petition is filed, an interpretation which would be directly in contrast with the objective purpose of the Act. Permitting such an interpretation would mean that the parties would paradoxically be required to file section 11 petition to prevent the lapse of interim measures granted under section 9 of the Act, even when the respondent is cooperating, the contractual appointment procedure is underway, or even when the section 25 notice has only recently been served. This is antithetical to the flexibility and autonomy provided in the Act. Then 36, the legal position as settled when applied to the present factual matrix yields a clear conclusion. The trial court passed an order dated 17/2/2024 granting ad interim injunction to the applicant. The period of 90 days as provided under section 9(2) of the Act would end on 17/5/2024. The appellant served notice invoking arbitration on 11/4/2024. The reply of the respondent 2 dated 23/4/2024 refusing to join in the appointment of arbiter entails that a notice had indeed been received and understood as an invocation of arbitral process by the respondent number 2. Under section 21 of the Act, the date of receipt of the notice is the date of commencement of arbitral proceeding. Even if 23/4/2024, the date on which the reply sent by the respondent number 2 is taken to calculate the period of 90 days as stipulated under section 9(2) of the Act, and the consequences thereof provided under Rule 9(4) of the 2001 rules, the arbitral proceedings have commenced and well within the time and way before expiry of such period. Now, Your Lordship, my lord, in our case, Your Lordship has already taken note of the my lord dates.
Last time, personal role in a partnership,
So, my lord, on the maintainability of 227 petition, my lord, these are my submissions. These factors have not been considered, my lord. My submission is that, my lord, whether section 9 petition is maintainable or not, I am, my lord, drawing your lordship attention only to the limited extent regarding the, my lord, perversity. I am not, my lord, calling upon your lordship to decide on the maintainability of the section 9 petition. What I am on is that, my lord, I must be given the, my lord, interim protection by granting, my lord, the stay to the limited extent of, my lord, my participation in my partnership firm. My lord, if your lordship only 3 decisions on, my lord, what partnership, I may not read it, my lord, but I'll place the decision with your lordship, my lord. In fact, my lord, for your lordship convenience, my lord, we have highlighted the relevant portion. 3 decisions, my lord, on the dispute resolution of the partnership. Therefore, my prayer is very simple, my lord.
No, these decisions you are relying for them to
For the purpose of saying that, my lord, I have got the right to, my lord, participate in the partnership. I cannot be ousted from the partnership.
Determine the partnership.
Because, my lord, by the absolute order of injunction, my lord, the partnership has been determined. In effect, my lord, the partnership has been determined. I have been, my lord, thrown away from all my business. And it is not a case, my lord, when I am acting against the partnership. It is the respondent number 2, my lord, who is acting against the interest of the partnership, and he obtains an order of injunction, and the, my lord, trial court as well as the first appellate court, my lord, would not really, my lord, appreciate the law and the facts, my lord. So, my lord, that will be decided in the appeal. But I am bringing to your lordship attention only for the limited purpose of showing, my lord, the perversity, where, my lord, interference under 227 is the, my lord, only remedy I have.
Okay.
Oh, my lord.
Blanket order, sister concerns.
My lord, and the blanket order, your lordship will say, my lord, all sister concerns. We are, my lord, concerned with a partnership
And I have been, my lord, thrown away, not thrown only from that partnership, but all, my lord, the other sister concerns where I am a partner. And your lordship has already noticed the, my lord, fault which I did not point out. Your lordship has pointed out, my lord, the firm was restrained. That is a non-application of mine, my lord. Therefore, my prayer is that, my lord, your lordship will allow me to participate, my lord. I have given the undertaking that I am not going to freeze the account.
Okay. Yes, Mr. Chandrika.
May please, Your Lordship. My lord, first things first, the matter is fixed for hearing on 31st.
The appeal.
Yeah,
Day after tomorrow.
day afterwards.
So what is your submission?
My lord, firstly, my lord, whether at this juncture, this court will interfere with that order of interim stay, passed in an application for stay of the impugned order under section.
This petition may become infructuous if ultimately in appeal something is decided.
Yes, that is one way of looking at things, my lord. But what I'm going to submit is that this arduous task of examining whether the section 9 order is correct, whether the appellate court should have granted stay in the facts and circumstances of the case, since the matter is going to be finally decided shortly, my lord, day after tomorrow is the date of hearing. Should this court, under Article 227, examine the merits of the matter? Now, insofar as Article 227 is concerned, in fact, my learned senior friend had relied on Sundaram Finance, etc. There, the High Court had interfered under Article 227 and it was set aside. That is what had happened in Sundaram Finance, if I'm not wrong. Now, recently, because given the scheme of the Arbitration Act,
Yes.
given the scheme of the Act, my lord, Section 5 is very clear. Judicial intervention only as per the part of that Arbitration Act. That's number one, my lord. And Section 37, which essentially talks about orders passed under Section 9, also uses the word only. Now, slightly in a different context, my lord, the Honorable Supreme Court has said that Article 227 should not be invoked in any matter concerning arbitration, given the language of Section 5 and Section 37. If I may just, to begin with, Manoj, if I may just place that judgment.
No. In this case,
Yes.
their prayer under Order 41 Rule 5 was
Yes.
rejected.
Yes.
What relief they had against that order?
They have none, Manoj. In fact, I would also submit.
They don't have any remedy.
Manoj, insofar as this order is concerned, because ultimately, Manoj, if I may just quickly, 37 itself doesn't provide for stay, number one.
Okay.
Then secondly, my lord, even considering you can invoke 41.5, my lord, 41.5 order cannot be a subject matter of challenge under Article 227, given the scheme of the Act. My lord, it may be on a slightly different context, my lord. If your lordship may kindly have this judgment, this is Haven Construction versus Executive Engineer Sardar Sarovar Narmada Nigam, 2021, 1 SCC 75.
Para?
My lord, will first have paragraph 12.
Yes.
We need to note that the Arbitration Act is a code in itself. This phrase is not merely perfunctory, but has definite legal consequences. One such consequences is spelled out under Section 5 of the Arbitration Act, which reads as under. Section 5, extent of judicial intervention. Notwithstanding anything contained in any other law for the time being in force, in matters governed by this part, no judicial authority shall intervene except where so provided in this part. Now, where so provided is Section 8, Section 9, Section 34, and Section 37. these are the only provisions in this particular part which speaks of judicial intervention. The non-obstante clause is provided to uphold the intention of the legislature as provided in the preamble to adopt the UNCITRAL model law and rules to reduce excessive judicial intervention which is not contemplated under the Arbitration Act. Now, if your lordship may turn to para 17 minutes, bottom of that page. Thereafter, respondent number 1 chose to impugn the order passed by the arbitrator under 16(2) of the Arbitration Act through a petition under Article 226, 227 of the Indian Constitution. In the usual course, the Arbitration Act provides for mechanism of challenge under Section 34. The opening phase of Section 34 reads as, recourse to a court against an arbitral award may be made only by an application for setting aside such award in accordance with subsection 2 and subsection 3. The use of term only as occurring under the provision serves two purposes of making the enactment a complete code and lay down the procedure. Now 37, the provision under which the appeal is pending, also contains the word only, just for context. Now, that bottom of that page, Manoj, after the decision of the Supreme Court is cited at para 18, the last portion, it is therefore prudent for a judge to not exercise discretion to allow judicial interference beyond the procedure established under the enactment. This power needs to be exercised in exceptional rarity, wherein one party is left remediless under the statute or a clear bad faith shown by one of the parties. The high standard set by this court is in terms of the legislative intention to make arbitration fair and efficient. In this context, we may observe Deep Industries versus ONGC, wherein the interplay of Section 5 of the Arbitration Act and Article 227 of the Constitution was analyzed as under. Most significantly of all is the non-obstante clause contained in Section 5, which states that notwithstanding anything contained in any other law in matters that arise under Part 1 of the Arbitration Act, no judicial authority shall intervene except where so provided in this part. Section 37 grants a constricted right of appeal against certain judgments and orders and no others. Further, the statutory mandate also provides for one bite at the cherry and interdicts a second appeal being filed under 37(2). That being the case, there is no doubt whatsoever that if petitions were to be filed under Article 226 and 227 of the Constitution against an order passed in appeal under Section 37, the entire arbitral process would be derailed and would not come to fruition for many years. At the same time, we cannot forget that Article 227 is a constitutional provision which remains untouched by the non-obstante clause of Section 5 of the Act. In these circumstances, what is important to note is that though petitions can be filed under Article 227 against judgments allowing or dismissing first appeals under Section 37 of the Act, yet the High Court would be extremely circumspect in interfering with the same, taking into account the statutory policy as adumbrated by us herein above, so that interference is restricted to orders that are passed which are patently lacking inherent jurisdiction. In the instant case, respondent number 1 has not been able to show exceptional circumstances or bad faith on the part of the appellant to invoke the remedy under Article 227 of the Constitution. No doubt the ambit of Article 227 is broad and pervasive. However, the High Court should not have used its inherent powers to interject the arbitral process at this stage. It is brought to our notice that subsequent to the impugned order of the sole arbitrator, the final award has been rendered on merits, etc., etc. So maybe on a different context, but what we can gather from this judgment is, given Section 5, that the interference would be permissible only in terms of that particular part of the arbitration agreement. Any other interference under Article 227 would, I'm not saying it will be totally barred, but only in exceptional circumstances and only it's a rarity in it.
In Section 37,
yes,
there is no similar provision like Order 41 Rule 5.
No, there is. In fact, the First Appellate Court has taken that aspect into consideration. My lord, first of all, there is no power of stay given in 37 to stay the order under Section 9. Now, even if we borrow 41.5 from the CPC, my lord, that also courts have interpreted that 41.5 will apply only when there is, it can only stay the execution of a decree. So therefore, since injunction orders by themselves are not executable in nature, 41.5 would not even be applicable.
So there may not be any circumstance where the order appealed may be stayed under 37.
Yes, there are line of judgments which were cited by the learned First Appellate Court, and if your lordship may take those portions of the order, page 758. Page 754 onwards.
Yes.
Paragraph 12, if your lordship has.
Yes.
If we read section 37 of the Arbitration and Conciliation Act,
Yes.
we found that there is no provision of any kind of stay in respect of any order passed during arbitration proceedings in respect of which appeal is preferred. If we carefully peruse section 5 of the Arbitration and Conciliation Act, which deals with the extent of judicial intervention, we found that the Act itself reflects that the Act is itself a code which provides remedies in respect of any order passed under the Act within the Act itself. By filing an application under section 9 of the Arbitration and Conciliation Act, the opposite parties have obtained an interim order and thereby restrained the bank from freezing the account of the opposite party number 1. The Honorable Madhya Pradesh High Court in the case of Vasant Dwikar Patrika reported in so-and-so in paragraph 16 observed as follows. It is therefore clear that except the Allahabad decision, there are no decisions where this question has been specifically examined. An examination of the language in subclause 1 of Rule 5 clearly provides for stay of proceedings under a decree or order or the stay of execution of a decree. It is therefore clear that so far as an order of temporary injunction as was granted in the case is concerned, there are no proceedings under the order which could be stayed, nor is there any question of execution which could be stayed. In my opinion, therefore, no order could be passed by the learned appellate court in exercise of the jurisdiction under sub-rule 1 of Rule 5 of Order 41. In another case reported in so-and-so, the Madhya Pradesh High Court in para 8 observed that from a perusal of Order 41 Rule 5, it is clear that the appellate court is provided with jurisdiction and power to stay execution of a decree. Decree or order of injunction cannot be executed. It is only when breach of injunction order is committed by a party who had failed to who had the opportunity of obeying the decree and has failed to obey. An application can be filed under 2132 of CPC for his detention in civil prison or by attachment of his property or both. Power under 41.5 is stay on execution of decree. Since decree of injunction cannot be executed and the same comes into force immediately after passing of decree, and in case of breach of injunction, party aggrieved may file an application under 2132 in view of the aforesaid appellate court had committed an error in passing an order of stay over a decree of injunction. Now the First Appellate Court does not endorse these ratios in totality, but it says that today we cannot decide the stay application dehears the merits of the appeal. So therefore, we will defer adjudication until we hear it on merits, and there should not be any stay, because ultimately to stay, the learned appellate court has to visit the merits of the case. And that is exactly what is going to happen if your lordship, in my respectful understanding, examines the prayer for stay. Now, my lord has already seen, the petitioners have already placed reliance on the findings of the Section 9 order, my lord.
Yes.
So it is expected that this court will return findings regarding the sort of validity or the correctness of the findings by the Section 9 court.
Which will have bearing on the appellate court.
It will have bearing, and more particularly that will be exercising powers vested specifically on a commercial appellate court under Section 37. So then we again come in loggerheads with Section 5 of the arbitration. Because to examine the correctness of the order under Section 9, there is a forum or there is a provision under Section 37. Now,
No, if Section 37 appeal takes time and the order 9, Section 9 order results into some grave civil consequences like ousting a partner from partnership firm, what remedy he has?
Manoj, I'll address as so far as what civil consequences it may have. I will address that question, Manoj. But because the Act itself doesn't envisage this situation, so therefore we have to assume that it can either get it set aside in the final proceedings of 34.
Appeal has to be decided expeditiously.
Appeal has to be decided. In fact,
Expeditiously.
this court has the occasion to deal with another arbitration matter where Section 16 decision was challenged under Article 227 before this court. And it was urged that 227 should be exercised because I can't wait until the award is passed. So there also, Honorable Supreme Court said eventually that the Article 227 should not have been sort of entered in. Because ultimately, whatever remedy they have, they'll have it against the final award. I'll place that order. So therefore, to sort of consider the prayer for stay, your lordship has to venture into the correctness of the order under Section 9. And if this, in my respectful understanding, if that exercise is undertaken, it will be akin to exercising the power under Section 37 itself, which is reserved for the Commercial Appellate Division.
When construction is talking when.
Yes.
So therefore, my lord, given the ratio laid down by the Supreme Court in the case of Bhaven construction, I would say that this application itself is not maintainable, number one. And secondly, even if it were to be considered as maintainable, this is not at this juncture to sort of examine this question would tantamount to entering into the merits of the appeal, which may prejudice either of the sides tomorrow or day after tomorrow. My lord, another a preliminary objection that I would like to take . If your lordship has page 229 of volume 1 for a moment.
Yes.
Now, this application for modification was filed on behalf of Lokesh Anand Singhal. Number 2 is Associated India Private Limited, and the signatory is Srimati Indumati Singhal. Page 229. Has your lordship found it? And Indumati Singhal has signed.
Yes.
Now, if your lordship may have the second volume at page 650.
Six five zero.
650.
Yes. Yes.
650.
Now, the following page, if your lordship takes. So throughout, my lord, Associated India Limited and Indumati Single were shown to be objectors so as to give a projection that it is a dispute between the families and the single branch of the firm is together in this. Now, paragraph 12, my lord, that at the very, paragraph 2, I'm sorry, that at the very outset, at page 651, that at the very outset, I would like to bring it to the notice of this honorable court that the applicant number 1 had made me sign the written objection in misarbitration case number so-and-so and the petition number 968 dated 21/2/25 without disclosing the facts narrated therein. It be clearly stated that I am the elder of the single family and the entire episode resulting to the institution of the instant proceeding has been born out of a dispute which had arisen between my two grandsons. Shri Manoj Kumar Jalan and the Jalan family have always been a close friend of the single family and he has never taken any step to defraud his partners. That I say that the statements made in misarbitration case number regarding the exit of Associated India from the partnership firm was well within the knowledge.
Yes.
Was well within the knowledge as well as that was well within my knowledge as well as that of the other directors, including Lokesh Anand Singhal and Shilpi Anand Singhal, and all such statements made in misarbitration case number 205 of 2024 are correct and was with the consent of all stakeholders. That in petition 968 dated 21/12/2025, that's the application for vacating, my lord, where her signatures figure, and the written objection filed in misarbitration case number so-and-so, some statements have been made regarding siphoning of funds, illegal removal of Associated India Private Limited, illegal removal of Shilpi Anand Singhal as director of various companies of the Protect Group and other such allegations. The same are completely false and without any basis. Though I was a signatory to the petition number so-and-so and the written objection filed in misarbitration so-and-so, the same was signed by me with trust upon my elder grandson, Shri Lokesh Anand Singhal. It is only upon coming to learn about the real contents of the said allegation on 15/6/2025, I have been compelled to file this affidavit to bring it to the knowledge of this honorable court to clarify that I do not endorse the allegations made in petition number so-and-so, and as such, I do not wish to pursue the same. Now, your lordship will have page 654.
Yes.
Now, after this affidavit was filed, the court takes note of that. And somewhere in the middle of that order at page 64, your lordship will find today a new counsel. 654.
Yes. Today in new council.
Yes. Has your lordship found it?
Yes.
Today, a new counsel, namely Mr. K.P. Borua, appeared for proforma OP number 4, who filed Wakalatnama and submitted a scanned copy of the affidavit, wherein the proforma OP number 4 stated that the applicant OP number 1 had made her sign on the written objection in misarbitration case number so-and-so and the petition number so-and-so without disclosing the facts narrated therein. Considering the submission of OP number 4 and the fact that OP number 4 is already represented by OP number 1, her appearance is required before the court. As such, OP number 4 is directed to appear before the court on the next day.
Who is open? Indumati
Singhal. Now, following page, my lord.
Yes.
Petitioner OP number 1 to 4 and 5 are represented. The newly engaged counsel of proforma OP number 4 has submitted the original copy of the affidavit, scanned copy of which was submitted on 19/6/25. The earlier engaged counsel for proforma OP number 4 submitted that the newly engaged counsel for proforma OP number 4 has not obtained NOC for them, from them. And two sets of advocates cannot represent the same party. Learned counsel appearing for proforma OP number 4, white petition number so-and-so, prayed for allowing the proforma OP number 4 to appear through video conferencing mode contending that pro forma OP number 4 is at Kolkata due to demise of her sister. Heard and perused, considering all aspect is allowed petitioner so-and-so for extension added. Now, your lordship will find next page, the next order on 21/7/2025.
Yes.
Petitioner OP 1, 2, 3 and pro forma OP 4 and 5 are represented. Learned Senior Counsel, Mr. So-and-so, produced an affidavit signed by OP number 4, wherein it is stated that she had withdrawn her wakalatnama dated 19/6/25 from advocate KP Boro and Raghav Sharma and instructed both the counsel not to represent her. So now there's almost a tug of war. They get a fresh affidavit saying that no, we have not engaged KR Bora. Mr. Roy will continue to represent me. Mr. KR Borua objected against the affidavit and submitted that he is advocate of OP number 4. So both claim to be representing OP number 4 and prayed to allow him to do video call to OP number 4 as per order dated so and so. Accordingly, OP number 4 appeared on screen through video call, and on being asked by this court as to who is representing her in this case, she replied that her advocate is KR Borua.
Now, what do you want to emphasize?
Now, my lord, then again at page 58, they eventually surrender. They say that we are not representing OP number 4. Now, what I want to show from this is OP number 4 had a pivotal role in the proceeding because the major allegation was OP number 4 was illegally ousted. So therefore, it was projected as if she came for vacating the order. She made her stand clear that no, I side with the petitioners. It is my grandson who's creating all the trouble. The moment she sort of established her stand, they stopped representing her, and in the appeal, my lord, they filed an application to strike her name out. The moment she sided with the petitioner and made her stance clear that I am not with the petitioners of this revision petition, her name has been struck off, and even in this proceeding, she is not made a party.
22, 27.
Whereas in my respectful submission, she is a necessary party here. And if she is not a party here, the revision petition also suffers from a defect of non-joinder.
No, her name was not struck out in the
In the
section 9.
application, no, she got made a party.
Only in the appellate stage.
Appellate stage, they said they knew they would not, she would not support them, therefore they got her struck off. Oh.
Okay, that's wrong.
And here also she's not a party.
That's a wrong submission, but I'll try.
That order your lordship finds at page 740. Seven 14. Now, Prohibitions pro forma for OP4 in the original proceeding became pro forma respondent 9 in the appeal. Paragraph 6, sin petition number so and so filed by the appellants striking out the name of pro forma OP respondent number 9 Associated India Private Limited from the instant misject case and also in the connected appeal. Copy of the petition is received by the so and so. Heard the counsel for both sides, having heard prayer for petition appellant so and so is strike out the name of pro forma respondent number 9 is allowed in misject case number so and so. Now, after this, does the appeal and this revision petition not suffer from a defect of non-joinder? One of the alleged partner, whom they say there was reconstitution to her deprivation or to the deprivation of Associated India Private Limited, is now not even a party in this proceeding.
Indumati Singhal was a partner In the original partnership deed.
Yes, through Associated India. Associated India, basically a company who was a partner there, and therefore she was also made a party.
Later on, there was some modification.
Some reconstitution. Then they made allegation that Associated in India Private Limited and her director Indumati Singhal were ousted illegally. So therefore, we made all of them a party. They filed it on behalf of Associated India, represented through Indumati Singhal, saying that the reconstitution is banned. Thereafter, Associated India, through Indumati Singhal, again cleared her stance that no, we have no difficulty, we are with the petitioners. The moment she cleared her stand in the appellate proceedings, her name was struck off. So therefore, my second round of objection to the maintainability is non-joinder of necessary parties.
Yes.
So firstly, these are three submissions that I have insofar as the maintainability of the application. Firstly, Article 227 cannot be invoked in the given facts and circumstances. Secondly, considering the stage, this revision petition or the prayer for stay should not be entertained. And thirdly, the petition itself suffers from a defect of non-joinder. Now, my lord, on the issue of what does the appellate court say, my lord? Just two paragraphs I'll show from that judgment, my lord. I'm sorry, that order declining stay. First, at page 752 of that same volume, which your lordship has probably, volume 2.
But it would require hearing.
Yes,
That was their reasoning.
Two paragraph 10 and 20, it has clearly said that I cannot decide it now because I'll have to visit the venture into the merits of the case. So I'll decide it when I decide the appeal. And if your lordship weighs the balance of convenience, also I find nothing wrong because he was meddling with the affairs of the firm, no matter what the language or the tenor of the letter is. The result that it yielded was freezing of bank accounts. He reached out to creditors, he lodged FIRs, etc. So therefore, I had relied on those judgments by the various high courts that in such cases of wanton misconduct or actions detrimental to the firm, there can be instances when the court can restrain a party from interfering for the welfare of the firm. And staying the impugned order would therefore mean that my accounts again go frozen. So therefore, in the fitness...
Their submission is that they are conceding regarding the freezing of accounts. They are saying that this time we will not go for freezing of
that concession or sort of undertaking, if your lordship sees at page 329, which was referred just now, is in my respectful submission not honest and is not unqualified and is conditional. Page 329 for a moment, the affidavit which was shown to suggest the undertaking, suggest that they had given an undertaking that they will not. What is the undertaking if we read carefully, my lord?
Yes.
Now, page 330, how is the undertaking given?
Yes.
A, 330, my lord, page 330.
Yes.
All the withdrawals, debit instruments, online, offline from bank account, everything of all the entities of Protect Group and its sister concerned subsidiaries with OP number 7 bank and any other bank must be done after obtaining signatures of all partners in case of firms and all directors in case of companies respectively. There are thousands of transactions, my lord. Now, everything should be routed through all the partners. The partnership agreement says there will be management through one partner. And he says everything. So basically, he holds up one transaction. He says no, he doesn't give approval. The transaction gets held up. Then B, all decisions of all entities of Protect Group and its sister concern subsidiaries must be done after obtaining approval in writing with signatures of all partners in case of firms so and so. So therefore, he will sit as if he will scrutinize all transactions, he will give an approval and only then he'll go through. Matlab, this firm is handling so many real estate projects. For each and every transaction, if we have to beg at his door for his approval, my lord, it's one and the same thing. My lord. Now, coming to the issue of section 9(2). In fact, Regenta Paradise, if I've gotten the name correctly, is clearly in my favor, Regenta Hotels. Now, what is 9(2) essentially saying, Manoj?
Yes.
Nine two is saying where before the commencement of the arbitral proceedings, a court passes an order for any interim measure of protection under subsection 1, the arbitration proceedings shall be commenced. The word used is commenced within a period of 90 days from the date of such order or within such further time as the court may direct.
Yes. The instant case, you filed the application under 11 only in the month of February.
Yes, that is a submission, my lord. And that is that is legally not correct because the word used is commenced. And what is commencement is defined under section 21. Section 21 for a moment.
So even if you don't file an application,
Not necessary at all. The moment I send that notice and that request notice is received on received by the respondent, the proceedings have commenced. And that is what precisely Regenta Hotels is saying.
read 21.
21 says, unless otherwise agreed by the parties, the arbitral proceedings in respect of a particular dispute commence on the date on which a request for that dispute to be referred to arbitration is received by the respondents. I did it in December, starting of December. So I have complied with 9(2). And that is what Regenta Hotels have also said, my lord. Lord, I have the same judgment, but perhaps the paragraph numbers may not tally. The Regenta Hotels, if I may just.
Which para?
Para 23 first, no?
Yes.
Upon perusal of the binding decisions of this court and provisions of the Act, there is no doubt left with regard to the correct conceptualization of commencement of the arbitral proceedings under the Act. The settled position as emerged is that the commencement of the arbitral proceedings is a statutory event defined exclusively under Section 21 of the Act, wherein the respondent's receipt of a request to refer the dispute to arbitration sets the arbitral proceedings in motion, and no judicial application, whether under Section 9 or Section 11 petition, constitutes commencement. Therefore, the statutory consequences tied to commencement, including the mandate of section 9(2), must be assessed solely with reference to the date of receipt of the request, invoking arbitration under section 21 of the Act.
When have you sent the notice?
In December itself.
Where is that?
One second. My lord, has page 274 that their pleadings, they have said they have received it on, oh, I'm sorry, it's on 31st of January, my lord. I had 90 days. The order was passed on 1912 and I had done it on
Where?
page 274.
What is this? This is
the written objection filed
Written
by
objection.
them, where they have admitted.
okay.
The OP number 2, so-and-so issued a letter on 31/1/24 to the applicant serving a notice to initiate arbitration to resolve the dispute as per clause 21 of the partnership deed. So December, the order was passed. January, I shot the notice. The moment I send this notice, I have complied with section 21 and so have I complied with section 9.
So what is your submission regarding the observation made by the appellate court that it should have been vacated within 30 days? In somewhere, some observation was made.
Yes.
Well, the trial court. I think it was
not trial court.
Page 78 of the trial court order.
Page
178, page 571.
571, man.
571. Yes.
Last paragraph. Yes.
Last paragraph. 571.
78 and 78.
Page number 571.
My lord. Last paragraph.
Order under section 9. Last paragraph.
Yes, in the insert it is evident that resort to the proceedings under. In the insert case, it is evident, my lord. First, if I may read, my lord, from the paragraph above that. Now, the Honorable Apex Court in the above judgment at paragraph 28 observed, the very frame of section 21 provides that legislature has consciously delinked the commencement of the arbitral proceeding from any judicial proceeding. The court in so-and-so described this as a deliberate legislative choice model under unilateral framework meant to ensure that the commencement of arbitral proceedings is independent of procedural contingency. The above statutory scheme would be defeated if a court is permitted to substitute the commencement under section 21 with the date of filing of a section 11. Resort to proceeding under section 11 would be necessary only in case there is a refusal or no response to a notice under 21. In the instant case, it is evident and that though notices was issued to OP number 1 on 31/1/25 and he did not respond and to the said notice, the petitioner should have approached the High Court within 1 month after no response of the opposite party as per section 11. Hence, the ex parte order dated 19/12/2024 ought to be vacated. However, as the same is not vacated, I am of the considered opinion to dispose of the injunction petition today on perusal of rival submission of the parties, as no arbitral tribunal is constituted till date. I do not endorse with this finding. This is a wrong fact. If the order could be in my favor, this finding is wrong.
Okay. Yes.
Now, my lord, the entire allegation, the entire prayers of say is premised on the allegation that one particular partner has a competitive business. And therefore, they're saying that if the order is not stayed, he will continue to siphon off money because of the competitive business that he has. And therefore, the order is required to be stayed. The first question that would arise is there a bar? My lord, has the Partnership Act for a moment, my lord?
Okay. There is no bar for a partner to have another independent business.
Yes, my lord. In fact, it creates a provision where the parties may choose to include such a clause, notwithstanding Section 27 of the Indian Contract Act, which says that there cannot be any agreement in restraint of trade. Now, if your lordship has Section 11 for a moment.
Yes.
Section 11, my lord, determination of rights and duties of partners by contract between partners.
Yes.
Subject to the provisions of this Act, the mutual rights and duties of the partners of a firm may be determined by contract between the partners, and such contract may be expressed or may be implied by a course of dealing. Such contract may be varied by consent of all partners, and such consent may be expressed or may be implied by a course of dealing. Now, agreement in restraint of trade. Notwithstanding anything contained in Section 27, such contracts may provide that a partner shall not carry on business other than that of the firm while he is a partner. So the contract has to provide. Now, in this particular contract, there is no such prohibition, and on the contrary, my lord, your lordship finds at page 66, clause 6 to 20, my lord. So 11 is saying that notwithstanding Section 27, that there cannot be a agreement in restraint of trade. When it comes to partnership, it is optional. Parties may add such a clause in the deed. Now here, it is to my notice, I have not found any clause prohibiting that. Rather, at page 66, clause 20, your lordship finds
Yes.
that this deed of partnership shall not in any way restrict or interfere with any individual business or any other business of any of the partners. So this entire argument that he cannot, should not.
No. Their submission is not only having a separate business.
Right.
Their submission is that
I
you
get
are
it.
siphoning of money and
I get it, my lord.
putting it in.
But the projection that was made is I have a competitive real estate business, so which is the cause of apprehension. So I'm saying that even if that is a cause of apprehension, of course, siphoning, like your lordship said, is subject to proof, and if they are able to prove siphoning during the arbitral proceedings, which will eventually commence, then it's altogether a different thing. But
the deed itself provides for a
yes,
partners having independent
business.
Okay.
And there's no term in consonance with 11 of the Partnership Act.
Okay.
Now, my lord, a lot has been argued on the mediated settlement agreement.
Yes.
Now, first thing I must point out is this foundation of the mediation settlement agreement, your lordship will not find either in the objection or in the modification. Or in the application for modification. Initially, that mediation settlement agreement was not even produced. There was no foundation. There was no pleadings either in the objection at page 252 or in the modification application under 299 at page 299. There is not a whisper about this mediated settlement agreement. In fact, in those pleadings, they have said that it should go for arbitration, etc. It is only later on, by way of an additional affidavit, this was introduced for the first. And that was after closure of the pleading. So, first of all, Manoj, this was not your given case at the time of objection. It came much subsequently by way of an additional affidavit. And by which time, I think we had already completed the pleadings. Of course, this miscellaneous applications were filed, but this was not the original stand number one. Now, my lord, if your lordship has the Mediation Act for a moment. This came to replace the conciliation chapter of the Arbitration and Conciliation Act. Now, first thing first, to construe it to be a mediation settlement agreement, there has to be a mediation. There has to be a mediation agreement. Now, Section 4 of the Act describes a mediation agreement. Now, it says a mediation agreement. So, firstly, my lord, on facts, I did not have the adequate opportunity to sort of to contest this particular agreement because it was filed by way of an additional affidavit. Original pleadings did not have that stand at all. Secondly, my lord, for it to be construed as a mediation settlement agreement, it should be born out of a mediation. And for a mediation to take birth, there has to be a mediation agreement. Now, 4.1 says a mediation agreement shall be in writing by or between the parties and anyone claiming through them to submit to mediation all or certain disputes.
Okay, mediation agreement precedes mediation.
Mediation settlement. My lord, first mediation agreement, then there'll be a commencement. There's a section.
Mediation, then mediated settlement.
Settlement agreement.
Okay.
And then, so this entire, there's nothing, there's simply
So your submission is there is no mediation
mediation
agreement.
settlement. And this cannot fall.
No. Is it your submission? Because there is no mediation agreement between the parties.
Yes.
So what is mediation agreement?
Mediation agreement is something which is in writing whereby parties have agreed to submit to mediation. Then as per section 14, the mediation commences when notices are issued, just like in arbitration. Then it translates into a mediation settlement agreement under section 90.
So there cannot be a mediation without mediation agreement.
Yes, exactly.
Suppose parties don't have mediation agreement.
Then it will be, at least it will be a settlement matter. At best, it could be a settlement, a family settlement deal, but it will not have the force of a mediation settlement agreement, which is otherwise executable like a decree. Under section 27. And there are other loopholes in this particular agreement because section 6 again says it shall not be conducted for resolution of any dispute or matter contained in the indicative list under first schedule.
What is there in the first schedule?
Now, first schedule, if your lordship has 6, it says when third party rights are involved. Now, here, my lord, in this purported mediation settlement agreement, there are just 3 signatories.
But that is a subject matter of a different suit also.
And perhaps that cannot be a subject matter of a different suit because 27 says it's a decree. So it should ideally go to the executing court. And in any case, my lord, that agreement, it is not stamped, it divides companies among 2 families, my lord. It's not backed by board resolution, there's no stamp duty, all partners have not signed. It is actually a photograph of a particular document. That is how it was annexed. It's a scrap of paper, my lord, nothing more. And to sort of vest upon it the sanctity of a mediation settlement agreement, which is akin to a decree, will be a little too much, in my humble understanding. Page 90 is that mediation settlement agreement. Nobody's produced the authenticated copy. And importantly, under the act, it should be endorsed and sealed by the mediator. Page 90, your lordship will still find that thumb because it's a photograph. 90. Now your lordship will see here, my lord, SOC, Aerocity Private Limited, a company is being distributed, my lord. Is that how companies are demerged or liquidated, my lord? Now there are just three signatures. There's 7 or 8 partners, if I'm not wrong.
Yes.
Yes. And so far as civil consequences are concerned, my lord, there are two things which are perhaps not part of the record. First of all, my lord, perhaps your lordship may also recall that KYC issue was also a subject matter of the other suit or appeals of which were heard by your lordships. There also, my lord, KYC is just a ruse. They just want to somehow freeze the accounts because everyone, if all the partners except for these two petitioners have done and submitted their KYC. Because they need to sign a few declarations. Now they do not sign the declaration, therefore the KYC is held up. And taking advantage of that, they are only saying that you freeze the accounts because the KYC process is not complete. So KYC is essentially a ruse, nothing more. The intention is very clear and it had yielded that result because now we are trying to read between the lines to see whether this letter actually intended to close the accounts or not, but it yielded the exact result. After that letter, which was read out by my senior friend at page 94, my lord, the accounts were frozen. So, my lord, and insofar as
Yes.
insofar as civil consequences are concerned, my lord, we had submitted audited statements, my lord. In fact, they have been receiving profits from the firm, my lord. They were never in the management. Admittedly, the petitioner number 1 was not even there. He was pursuing education. Admittedly, his own statement before the bank said that he is the authorized person, he will do it. And he is reaping profits of whatever profits are being generated. We can produce that, my lord. In fact, the statements will show both Shilpi Anand Singhal and Lokesh Anand Singhal are receiving profits, my lord. And managerial functions, they anyways never exercised. And so far as banking operation goes, my lord, it's good that it is being done through a banking account, my lord. All transactions to the T are recorded. So therefore, if tomorrow they concede to arbitration, even if they go for a rendition of account, all these transactions remain in black and white. Now, so far as the arbitration petition is concerned, my lord, I must clarify that filing of section 11, given the judgment of Regenta Hotels, was not even necessary to comply with 9.2. But even otherwise, we had a manifest intention or a genuine need to go for an arbitration, which is why we filed arbitration petition 3 of 2026 before passing of the impugned order.
735
Same is pending.
And the same is pending. In fact, on 9 to 11/3, 22/5 and 13/7, I think 3 dates they have taken adjournment. They have not filed their response till now.
Yes. Start by 7:24.
So, my lord, there are several aspects which have to be considered before there is any sort of interference with this order passed under section 9. The first appellate court has rightly exercised this discretion and has held that I cannot besides stay divorce the facts, and therefore it has fixed the matter for hearing and has said that now perhaps they have not been there since 2024, my lord. And now, since 2024, so if they wait for another date or 2-3 dates, the appeal can be disposed of. But interfering at this juncture would be highly prejudicial to us, because if your lordship has to stay that particular order, your lordship has to record at least a prima facie satisfaction, that is, that the order passed by the commercial court is bad on these counts. And the moment this court touches the merits of the Section 9 order, it would tantamount to, with utmost respect, usurping the power of Section 37, which is vested with the Commercial Appellate Division.
Okay.
Lord, on merits, my lord, I can address all the issues, my lord, but I refrain from doing so because the appeal is pending, my lord.
Your lordship will kindly give me only 2 minutes by clock, my lord, to reply to my learned friend's submissions. Firstly, my lord, my learned friend was saying that the appeal is to be heard on Friday, and therefore, my lord, it can be traced out in the appellate court. But that your lordship has already responded, my petition will become infructuous. So I will not submit on that. Now, my learned friend has relied on a Delhi High Court judgment, that Bhavan construction. I'd like to point out, my lord, Bhavan construction, my lord, his copy is different. My paragraph will be a little different, my lord.
It was in
In my copy, my lord, the relevant paragraph would be paragraph 16. Paragraph number starting this being the case.
Whereas 1-6.
My lord, the paragraph 1-6 in my copy, my printout. Because, my lord, the answer, my lord, that my learned friend's ambition is answered here itself, my lord. That being the case, may I read that, my lord? Only one paragraph.
Yes.
Paragraph 16, my.
Yes.
That being the case, there is no doubt.
Paragraph 16 starts from thereafter.
Paragraph 16, my lord, in the copy that I have given, my lord, of Supreme today, in paragraph, my lord. That being the case.
No, I am going through the copy which has been provided by
That is a printout from Supreme today.
Supreme today. Bhavan construction.
It was quote করেছে আমরা page 10 হলে যাও
It should match para 19.
That is a quoted, my lord.
Okay, that is.
আপনি page 10 হলে আও page 10
19 or not 18. It will be 18, my lord. Paragraph 16 is, my lord, printed twice. Paragraph 16. Otherwise, my lord, the paragraph 16 starts thereafter. Respondent or choose to implement the order passed by the arbitrator under section 16(2). Then your lordship may skip that page. Then, my lord, paragraph 17, there is a quotation, my lord.
Yes.
A quotation of paragraph 11. Then, my lord, next page, your lordship will find paragraph 16. As your lordship got it, my lord. Only one sentence I will be reading from that. It starts, this being the case. At page number 10, my lord.
That is quoted in para 18. In para 18, two sub-paras are quoted.
My lord, quoted,
15.
paragraph 16 is quoted, my lord.
Yes.
This being the case.
Yes.
This being the case, there is no doubt whatsoever that if petitions were to be filed under Article 226 to 27 of the Constitution against order passed in appeal under Section 37, the entire arbitral process would be derailed and would not come to fruition for many years. At the same time, this line I'm my lord harping upon.
At the same time, we cannot forget that Article 227 is a constitutional provision which remain untouched by the non-obstante clause of Section 5 of the Act. Therefore, my lord, your lordship's power under Article 227 cannot be curtailed by, my lord, referring to the other provisions, more particularly, my lord, the Section 5 of the Act. And this decision, your lordship will kindly take note of. This is a judgment of 6th of January 2021. And in this case, my lord, neither Farm of Ashok case, which I have relied upon, 1999, and nor, my lord, 2004, and Sundaram Finance, these are not considered, my lord. I have placed those cases to show, my lord, that under Article 227, your lordship has the jurisdiction. So these are not touched, and my lord, this judgment also takes note of the fact that the power under 227 is not, my lord, is not remains untouched by the non-obstante clause of Section 5 of the Act. Therefore, my lord, this decision.
No, otherwise also statutory provisions cannot stop the constitution.
That is my submission, my lord. That has been recorded in this judgment itself, my lord. Therefore, this judgment is of no help to him.
No, that power is there, but whether to exercise.
Yes,
exercise
exactly.
that power.
Quite true, my lord. Quite true. Now, my lord, on Indumati Devi's, my lord, involvement, a lot of submission has been made. I'd like to point out, my lord, one thing. Indumati Devi, initially, she filed an affidavit against me, which is at page 650. That was against me. Then, my lord, page 726, she files an application in my support. And eventually, my lord, after all this hullabaloo, then at page 734, she has filed the application to delete her name. Your lordship may kindly come to page 734. That is her application. She says that my name should be deleted. I am not taking any sides. And accordingly, the order dated 27/4/2026 at page 740 was passed, deleting her name. My learned friend is, my lord, pressing upon the fact that, my lord, she is a necessary party, and therefore my revision petition is defective. Now she herself says that I am not taking sides. My name may be deleted. That has been deleted by the court on her application, and therefore she is no longer a party. How can my petition be, my lord, said to be a defective petition? Page 734 is her application. And on her application, this order at page 740, order dated 27/4/2026 was passed. Therefore, she is not a necessary party. She says, I am not taking sides. My name may be deleted. And it has been deleted. So that was the second submission of my learned friend. Now, my lord, regarding the mediation settlement, I have, my lord, already submitted, my lord, the existence of the mediated settlement may not be a consideration for your lordship right now, but rightly or wrongly, there exists one document which has not been, my lord, disowned by them. I ask myself this question: has Mr. Jalan disowned his own signature in this document? No. Did he not get a copy of this when this was signed? Yes. Did he not suppress this when he filed the application under Section 9? Yes, he suppressed it. Your lordship will see the conduct. And suppressing this, my lord, therefore my submission before your lordship is that your lordship need not go into the existence of the mediated settlement document on, at all, my lord. That may be a subject matter that can be decided, my lord, elsewhere. What I am on is that his own signature is there. He has never, my lord, disowned it. And now it says that it is a scrap of paper. And next, my lord, he was saying, my lord, about civil consequences. He says, my lord, thousands of documents are to be signed every day. I have to take permission from him. Why not? Why not we both sit together and sign the documents and checks? Why not? I'm a majority partner. He says that that will amount to freezing the account. Why? Am I not, am I acting against my partnership firm? It is you who is against, working against my partnership firm. And you are growing your own business, my lord. I have document to show, my lord. They have come up with many fresh advertisements and, my lord, fresh projects. And that is my allegation, of course, my lord, that he has been, my lord, since he's in full control of the accounts, my lord. I have got investment of more than 100 crores and I'm ousted from that. And you can spend any money whenever you like without even explaining to me or discussing with me. Is that the purpose of the partnership agreement?
Now they are doing the other business.
Other business they may do, but then, my lord, now they are coming up, my lord, a great number of projects, my lord. I can submit the documents if your lordship allows me, my lord. So that shows, my lord, that this allegation of siphoning has a prima facie, my lord, prima facie, it is established, my lord. And he wants me to keep out of the, my lord, business totally, where I am a majority partner. What I am praying, my lord, and he, my lord, doubts my undertaking before the trial court. What I have said, my lord, that, my lord, he says that it has, you have to read between the lines. What between the lines? I say that we have to jointly operate this. I have got a majority share. I am not ignoring you. I do not say that let me operate. I said let us sit together and manage our business. What is wrong in that? Why do you find it suspicious? Then your lordship may, my lord, formulate, my lord, what is the undertaking I need to give, my lord. I am ready to give that. Can I be ousted, my lord? Can I be ousted from my partnership and all the sister concerns by a blanket order? That is the issue before your lordship.
That is also the issue before the appellate court.
True, my lord. But then, my lord, this stay, in view of the perversity of both the orders, my lord, this stay ought to have been granted, my lord. Otherwise, my lord, my business, this partnership business will ruin. That is what is happening, and I am on the street practically, my lord.
Okay.
Now, my learned friend has read paragraph 14 and 15 of the, my lord, impugned judgment of the First Appellate Court, district judge's order, but, my lord, he has stopped reading paragraph 16. Your lordship will kindly read paragraph 16, the reasoning given at page 756. 14 and 15 has to be read along with paragraph 16.
Yes.
While denying this stay, my lord, this is the reason my lord, given. And this has been taken note of, my lord, one judgment of this honorable court.
What
Paragraph
reason?
16 at page 756.
What reason was it?
Page 756, my lord, paragraph number 16.
Yes, what it says.
The Honorable Gauhati High Court, in case of Rakesh Sharma and another versus Swaraj Chaudhary and two others, decided on 27/6/2024 in CRP IO 214 of 2024, had the occasion to discuss the order passed by the First Appellate Court, whereby the prayer for stay of injunction was rejected. The Honorable High Court, in paragraph number 8, 15, 16, and 17, has observed as follows. 8. The learned counsel for the petitioners has also criticized the order dated 3/8/2024 passed by the learned First Appellate Court by contending that no reason have been assigned, while declining the prayer for stay made under Order 41, Rule 5 of the CPC. It is submitted by Sri Roy that when the appeal was admitted, it was incumbent upon the learned First Appellate Court to grant stay. In support of his contention, Sri Roy learned counsel has placed on reliance on Moolchand Yadav. My lord, that has been quoted, paragraph 16. Then, my lord, paragraph 15, my lord, the case law cited by Sri Roy, learned counsel for the petitioners in the case of Moolchand Yadav, has laid down a caveat that the requirement of staying in order while an appeal is admitted is to be made only when such order has serious civil consequences. In the considered opinion of this court, the order of the learned trial court will not have any serious civil consequences, and rather the same would balance the equities. My lord, this is the finding on the, my lord, balance of my lord, equities, and my lord, that it does not have any serious civil consequences. And what is the consequence? Consequence is that I have been ousted from my majority partnership. I have been thrown to the street. And it does, and the, my lord, First Appellate Court holds
that, my lord, there is no serious civil consequences.
I think 91% of section 11.5.
Only one more submission, my lord. I'm sorry, my lord, I had to take your lordship.
Page 78 of page 78. Yeah, in internal page 78. There was no even application of land.
Okay, submission to the section
21 or 57.5. No.
Only one last submission.
Yes.
My learned friend has said that this finding at page 571 was, my lord, wrong. This is a clear finding, my lord, saying that my lord, the order ought to have been vacated. That is what he, my lord, the civil judge has
No,
said.
that observation is in relation to the ex parte interim order passed at the first instance by the
Yes, my lord.
Section 9 court. That stage has over.
Now, my lord, may I take your lordship to one provision, my lord? Because, my lord, section 21 of the Arbitration Act has to be read with, my lord, subsection 5 of section 11. This is my last submission. Well, I have not bothered your lordship any further, my lord.
Section 21 has to be read with.
Section 21. Commencement of arbitral proceeding.
Yes.
Because your lordship has taken note of the dates, my lord, when the section 9 petition was filed, when an ex parte order of injunction was filed, and when this, my lord, notice was sent to me, and when I did not respond, and what is to be done. Section 21 says, commencement of arbitral proceeding, unless otherwise agreed by the parties, the arbitral proceeding in respect of a particular dispute commences on the date on which the request for that dispute is to be referred to arbitration is received by the respondent. Now, your lordship may kindly come to section 11. Because, my lord, I have not responded to that. Then, my lord, there was delay on the part of the, my lord, the respondent number 2 herein in filing an application before this honorable court for appointment of arbitrator. Subsection 5, I'll read, my lord. Section 11 is appointment of arbitrators. Subsection 5 says, failing any agreement referred to in subsection 2 in an arbitration with a sole arbitrator, if the parties fail to agree on the arbitrator within 30 days from the receipt of the request by one party from the other party so agrees, the appointment shall be made on an application of the party in accordance with the provisions contained in subsection 4. So, my lord, this period is, my lord, stated here in subsection 5. That having not been complied, my lord, the time has elapsed. Therefore, my lord, my prayer is that your lordship will kindly protect me, protect the, my lord, the partnership, and give a, my lord, limited order, and whatever undertaking your lordship thinks, my lord, proper, we are ready to give, my lord.
You have anything to say about 11.5?
11.5, this Regenta Paradise, that could be a ground for delay in a section 11 petition. In fact, Regenta Paradise, this argument was only made. Regenta Hotel, I'm sorry. That why did you not approach? Your section 11 is beyond 3 months. Then the Supreme Court has said that is a misconception. Para 28.
My request was
11.5 is just giving me the cause of action to approach under section 11. 11.5 has nothing to do with 9.2. Just one point, if I may clarify, my lord, about that deletion of Indumati Singhal's name, my lord. Page 650.
Yes.
One question, yes, one question, yes, the application deletion.
635, 634. 634. So, an application for deletion 634.
sir. 634, sir.
734 नहीं सर 734 नहीं सर thanks sir
734
application 734 734
application. Now 734, if your lordship has. 734 was an application filed by Indumati Singhal before the trial court, and the trial court did not pass any orders. And 740, if your lordship sees the order of deletion, is by the appellate court. This was filed by an application in the year 2025, but since the second order came that your affidavit will be accepted, nobody pressed this application.
And the appellate court passed the deletion order on
their application, or that is at page 740. Because appeal, she was a party initially. My lord, and just two more things. I'll actually take 2 minutes by the clock, my lord. The assertion that they are majority partner is also not correct. If your lordship has page 358, my lord, the bifurcation of shares is given. They have 45%, so do we. And there are other companies which have shares. 258 is a partner, 358 is a partner's capital account. That is also not correct because half the singles are in this group, my lord. Only 2 persons from the single family is on that other side. Rest of them we are a cohesive unit, if I may call that. And lastly, my lord, this judgment, this had gone from this court, my lord, regarding 227's application, my lord. There again, perhaps your lordship may recollect. This was here also. Eventually the Supreme Court held from paragraph 25 to 30 that 227 ought not to have been exercised.
When is the date before the appellate court?
Day after tomorrow.
Day after tomorrow.
So if your lordship has to ensure that it is not rendered infractual, my lord, the order also has to.
Mr. M.K. Chaudhary. Oh, yes, yes. Bank is there.
Banks there. Big points of the my lord.
Yes, yes.
I am just reading my prayer, my lord. 2 decisions I have rendered. I am not reading it. Your lordship will kindly take note of, my lord. One is, my lord, High Court of Bombay, Prakash Bolukundar.
Mention the paragraph number.
Paragraph number I have, my lord, indicated in the judgment itself, my lord, for your lordship's convenience. I'll give, my lord, another say right now. With these 2 judgments, your lordship will kindly, my lord, take note of.
High Court of Bombay. Prakash Bolu.
Yes.
Yes,
SS Gupta.
And another is SS Gupta.
Which para you are?
Paragraphs are indicated at the top, on the side, top side, paragraph 3, 6, and 8, and 3, 10, 12. That has been indicated in the copy.
Indicated or highlighted?
If are highlighted, my lord, or
it is not. Okay, okay. 310. Okay, okay. It is there. And Punjab and Haryana High Court.
Yes.
Okay.
Yes.
Yes. Mr.
May I
Siddharth.
please, Lordship? Lordship, this bank has a very limited role in the dispute between the partners, my lord, here. So far, my lord, the dispute in the partners concern, my lord.
No, we are here have a very limited question to answer.
My lord.
Whether refusal by the appellate court under Order 41 Rule 5 was wrong. In that context, you make your submission.
No, my lord, at that context, we don't have to anything to say here because, my lord, there is nothing adverse against the bank there. Bank has just played a neutral role. Bank has submitted before the trial court that whatever order passed by the trial court will obey because we are just the custodian of the customer money. We have nothing to play, no role to play in this dispute. My lord, only I would like to deny here the certain allegations, my lord, raised by
But you
my
are not
learned senior friend, my lord.
doing that KYC.
Yes, my lord, regarding the KYC, my lord.
Answer. Who has not signed the KYCs?
My lord, the initial freezing of the account was initiated by the petitioner's request. He has come with a letter to the bank and bank has duly honored the letter and freeze the account. Thereafter, what happened, my lord? Again, they have come together and signed a document that no, we have sorted our dispute. Let the account be unfreezed. The bank has again unfreezed the account. Thereafter, again, my lord, after a few months, the petitioner has come again, approached the bank again. That no, again, we have some certain disputes arisen. You have to go to this audit and all these requests have been made. And he found the account to be freezed. So bank has freezed this particular Pride Realty account there, my lord. And thereafter, the petition under Section 9 has been filed by this respondent. So here, my lord, this KYC this process has been initiated in the 2000 first exercise was initiated 31st December 2024, my lord.
Yes.
And thereafter, my lord, again that exercise is going on. And the last, this exercise has been issued, the letter has been issued by the bank on 26/9/25, my lord. Now kindly see page number 465, my lord, of this volume 2.
Yes.
Page number 465.
Yes.
Yes, my lord, this letter dated 26/9/2025. It is addressed to the Pride Realty, so and so. Subject is the submission of pending documents for updating bank records for so and so, so and so, so and so, so and so, customer ID so and so. Thank you for banking with us. We are delighted to have so and so, so and so. So the next paragraph, my lord, we refer to our letter dated 11 February 25. That was the first letter, second letter. And 10 September 2025, with regard to submission of pending documents of caption accounts for updating bank records. With regard to the review of KYC documents submitted, we once again give an update on below shortfalls observed to comply with so that bank records are updated with the latest details submitted. So, my lord, these are the 6 articles, items which are required by the bank to complete the KYC process, my lord. And the next paragraph, my lord, the bank has clearly written there. We request you to visit the branch between 6 October 2025 to 8 October 2025 and meet the DBM so and so at IndusInd Bank Limited, Ganeshguri branch to complete the pending requirement stated above. So here, my lord, to complete this exercise, my lord, all the partners have to come together to the bank and they have to give a signature on the documents, joint signature. So here what happened, my lord, they approached the bank, but they came individually. So the exercise could not be completed, my lord.
And they will never come together because there is dispute going on between.
So that is the main thing, my lord. The KYC is pending, my lord. We have again issued another letter, my lord, on November 25. By the time this matter has been disposed and the things are now pending. And my lord, my humble submission is that, my lord, this KYC is not an issue before the trial court below. That is the only, they have come, the freeze account need to be unfreezed. The freezing was done for so and so purpose. The dispute was between the partners, siphoning of the amount. They are surrendering from the account some funds. So account to be freezed. We have freezed the account. Against that, the respondent is approached for unfreezing the account. KYC is never this issue before the court below. To settle the issues between the partners, my lord, they are projecting this KYC here now.
Okay.
These are my humble submission, my lord.
Only one sentence in this reply, my lord. KYC is a, my lord, statutory requirement. They have to do it. And my lord, my submission is a question to myself or to the bank, my lord. Is there any order from any court that Manoj Jalan should be the sole signatory of all the firms and companies? If there is no order, then how do you, within 6 months, take a different stand and say that I am not a partner? This is my limited submission. that shows the, my lord, the hand in glove nature of the bank with the respondent number
Well,
two.
bank here is not an investigation agency or any vigilant to investigate who is the correct partner, who is the not a
No,
partner.
on what basis you are?
But that is the mode of operation they have signed, my lord, before the bank.
All the partners have signed.
But the
Authorizing
initially, my lord,
Manoj Jalan.
Initially, they have signed, given the mode of operation that Manoj Jalan is the authorized signatory. Then thereafter, again, the dispute occurred, account was freeze. Again, they come with a letter to unfreeze the account. There again, they have signed and said that Manoj Jalan is the sole authority.
Which letter?
616. That was absolutely at mediation settlement, my lord. Because pursuant to that medial settlement, the understanding was that, my lord, it will take some time. In the meantime, let me operate. So, my lord, I had, believing the respondent number two, I had given that undertaking, the let him operate the bank account, and he has taken advantage of that.
But it is in the page number 661, my lord, where they have jointly given the authority to Manoj Jalan, my lord. This is volume 2, my lord.
Settlement is of such a.
Okay, heard Mr. M.K. Chaudhary, the learned senior counsel assisted by Mr. M. Sharma. The learned counsel for the petitioners. Also heard Mr. B.D. Deka, the learned counsel appearing for respondent number 1 to 6. Stop. Also heard Mr. B. Singha, the learned counsel appearing for respondent number 7 and 8.
Well, A.K. Gogoi.
Sorry. Mr. A.K. Gogoi, the learned counsel appearing for respondent number 7 and 8. Hearing concluded, let this matter be listed for delivery of judgment on 31st July 2026.
My learned friend, Mr. Sharma is also with me, my lord.
Oh, M.K. Chaudhary, learned senior counsel, as well as Mr.
A.K. Sharma.
A.K. Sharma, learned senior counsel, assisted by Mr. M. Sharma. Day after tomorrow.
Obliged.
Obliged.
Highly obliged.
Separate file download. I am taking a short break.
In this case, I have seen lordship. From our office, it has been gone on 21/5/2026. I have telephonically communicated also to the IO lordship. But they have stated that they have not received.
Oh. Then.
But from our office, I have asked lordship the office.
It is a case involving POCSO method.
Yes, Lordship.
What is the stage of the trial?
Evidence says, Lordship, there are, Lordship, 10 witness, Lordship, and among them, Lordship, 8 witness were examined, Lordship. IO and doctor, they are remained to examine. So, Lordship, he is behind ever since, Lordship, 2022, Lordship, 2025, Lordship. Lordship, today he has completed, Lordship, 520 days, Lordship.
But the offense is also
Yes, Lordship.
grave offense. Now what is to be done?
Amicus may be appointed in person. Otherwise, it will take another long time because they haven't stated that they have.
Heard. Miss R.J.V. learned counsel for the petitioners. Also heard Mr. K.K. Das, learned additional public prosecutor, who submits that though who submits that, though the office of the public prosecutor shows that, though the records available in the office of the public prosecutor shows that the notices were sent through email to the concerning jurisdictional police station. However, he has been informed by the officer in charge of which station? Tejpur police station, that they have not yet received the notice. He submits that since much time has lapsed since the filing of this bail application, and this case involves offense under POCSO Act, and amicus curiae may perhaps be appointed to defend the cause of respondent number 2. Learned counsel for the petitioner is also agreeable to the said proposal. As such, yes, Mr. Das. Any amicus present in the court? Mr. S. Das is appointed as amicus curiae to defend the cause of respondent number 2 in this case. The petitioner is directed to furnish copy of bail application along with annexures to the newly appointed amicus curiae. The registry shall reflect the name of Mr. S. Das as amicus curiae represent for amicus curiae in this case. List this matter when? How much time? After 2 weeks.
2 weeks. No.
List this matter again on 18th of August.
I didn't notice.
But
there are 3 IAs, my lord, for substitution of the deceased respondent.
Who is appearing for? Who is appearing?
Disappearing in this case. He's on his way.
Yes, Mr. Nath.
Well, the sole respondent died, Lord. We have filed application for substitution, condonation of delay and setting aside abatement of the appeal, Lord. The Lordship on the last occasion has issued notice. My learned friend, he appears for the legal heirs, Lord.
Setting aside abatement. Which application is for setting aside abatement?
Lordship. Plus setting aside,
2030.
setting aside abatement.
2030.
Yes.
Is the delay condonation.
And delay condonation has to be taken up first.
Yes.
Lordship.
You are opposing?
45 days delay, man.
Okay. Setting aside abatement for delay in filing the regular first appeal.
No, my lord. My lord, in fact, delay in filing the setting aside the substitution petition.
Which one is the substitution?
During pendency of our application, my lord, the respondent, he died, he expired.
Heard Mr. D. Nath, the learned senior government counsel, appearing for the applicant. Also heard Mr. S. Das, learned counsel for the
This he substituted legal heirs, my lord, he is appealing for.
learned counsel for the opposite parties. This application under Section 5 of the Limitation Act has been preferred by the applicants praying for condoning the delay of 45 days in filing the application for setting aside abatement and setting aside abatement of appeal on death of whose death?
Faizuddin Ahmed. the
Sole
respon-
respondent.
Sole respondent.
Death of sole respondent, as well as for filing substitution applications. Learned Senior Government Counsel submits that the cause of the delay has been stated in paragraph number
But in paragraph number 3, 4, madam.
3 and 4 of the instant application. So, learned counsel for the opposite parties submits that considering the short period of delay as well as grounds stated in the interlocutory application, he does not have any objection if the delay is condoned. Stop. After considering the submissions made by learned counsel for both sides, as well as going through the grounds stated in the instant interlocutory application, this court deems the grounds stated to be sufficient cause which prevented the applicants from approaching this court in filing the application for setting aside abatement as well as substitution petition within prescribed period of limitation. As such, the delay of 45 days in filing the said applications is hereby condoned, and this interlocutory application is disposed of. Abatement. This heard so and so, same naam takin. This application under Order 22 Rule 9 and Rule 11 of the Code of Civil Procedure 1908 has been filed by the applicants praying for setting aside abatement of the appeal on the death of the sole respondent Faizuddin Ahmed, who expired on
24/11/25.
24/11/25. The delay in preferring the instant interlocutory application has already been condoned in the connected IA number 2030/2026. The learned counsel for the opposite party has not opposed to the prayer. Stop. Considering the grounds stated in the instant interlocutory application, the prayer is allowed, and the abatement of appeal against the sole respondent on his death is hereby set aside. Substitution. Overall 2032. This one is 2031. This order will be in heard so and so. This application under Order 22 Rule 4 read with Section 151 of the Code of Civil Procedure has been filed by the applicants praying for substituting the legal heirs of the deceased respondent, namely Faizuddin Ahmed, who expired on 24/11/2025. 5. I have I have considered the submissions made by learned counsel for both sides. Considering the averments made in the instant interlocutory application, the substitution application is allowed, and the names of legal heirs of the deceased respondent, namely Bashiran Nessa, within bracket wife, Saddam Hussein, within bracket son, Rahul Amin, and Rahul Amin, within bracket son, are allowed to be substituted as respondent number 1, 1, 1, 2, and 1, 3 in place of the deceased respondent Faizuddin Ahmad. This interlocutory application is accordingly disposed of. The appellant shall file an amended cause title of the memo of appeal within 15 days from the date of this order.
But one more supposition that in the meantime, matter, the dispute pertains to minor compensation of 15 lakhs, which is awarded to the deceased respondent matter. So, matter, can this matter be referred to the district litigation center matter for settlement? Because the execution case is pending there.
No, let this submission you can make in the appeal.
When appeal, there is an issue, my lord. There is a delay of around more than 600 days, my lord. So it will take time, my lord.
Appeal is also barred.
Yes.
It was a delay is there, my lord. My friend is
Delay has not been condoned.
No,
delay. My friend appears, my lord. Lordship may condone the delay and take the appeal on board, and we are ready to go for here also we can go for mediation, my lord. The matter can be sent for mediation. Ultimately, my lord, 15 lakhs rupees has been directed to be paid. Considering the value of a brand new car, our contention is that as per the insured value of the vehicle, the amount should have been fixed.
All these things can be considered, my lord, in the both parties, my lord.
Yes, yes.
Have some settings, my lord, together.
Yes, yes.
And it will be better, my lord, since it is a district level issue, my lord.
That's
No, but where will I pass that order?
My lord, in the IA. IA.
I is only regarding.
Yes, because this is the main appeal is yet to be numbered, registered. So any order which has to be passed will have to be passed in the IA.
Which I?
IA number 648.
That is for condonation of delay, my lord.
648.
Well, I humbly submit that IA may be allowed and appeal may be numbered and then parties may be sent for mediation, my lord.
You have to. The last order क्या था? Substitution में. Read complete sentence.
No, condonation of delay, condonation of delay,
Last line, last complete sentence. Memo of appeal and also in the interlocutory, also amended cause title in the interlocutory application number 648/2025 within. You file the memo of appeal, amended cause title in both.
In both I'll file.
We'll dispose of this, admit the appeal, then we'll send it for mediation. Please this matter at a short.
Well, within 3 days I'll file.
17th.
17th of August.
17th of August.
Well, I have to file the amended cost title within 7 days.
7 days.
7 days.
RFA নহয়. 648.
Well, this is an appeal for enhancement, Lordship. Notice may issue, Lordship. Other side has already appeared.
Heard Mr. M. Khan, learned counsel for the appellant. Also heard Mr. What is your name?
Tidas.
You are
Yes, Your Lordship.
appearing for
For respondent,
which respondent?
only sole respondent, the Oriental Insurance Company.
Okay. Also heard Mr. D. Das appearing for respondent insurance company. Respondent within bracket Oriental Insurance Company. This appeal under section 173 of the Motor Vehicles Act 1988 has been preferred by the appellants / claimants, impugning the judgment and order dated 6/9/2024 passed by the Motor Accident Claims Tribunal, Bongaigaon in MAC case number 66/2020, whereby the appellants were awarded compensation amount of rupees 25,07,040 only, along with interest. The appellant is basically aggrieved with the quantum of compensation awarded to them. Issue notice. Since this you cannot make only insurance company as party. Owner has to be made part because insurance company is indemnifying the owner. So you cannot exclude the owner. You have to make him party.
Yes, Lord, only for quantum, Lordship, that's why, Lordship. If the insurance file this appeal against the DL, etc., Lordship, questioning that, then their presence would be necessary. But here in this case, only for quantum.
Since the respondent is represented by the engaged counsel, no formal notice need to be issued. The appellant shall furnish
Petition copy, yes, sir.
the copy of memo of appeal along with annexures to the learned counsel for the respondent within 2 days from the date of this order. Let the records of MAC case number 66/2020 be called for from the Motor Accident Claims Tribunal, Bongaigaon, registry to take steps for requisitioning the records. Let this matter be listed on 7th of September.
Item 8. Highly applicable.
May it please your lordship. My lord, this appeal is filed by the insurance company,
My
lordship.
Item number 7, Lordship, my name may be reflected, Lordship, in the cause list, my name does not be reflected.
Name of Mr. M. Khan, पहले का order. Name of Mr. M. Khan may be reflected as the engaged counsel for the appellant in the cause list henceforth. Yes.
Here, lordship, admittedly, 3 vehicles are involved in the accident, lordship. 2 motorcycles and 1 auto rickshaw, lordship. And
3 vehicles.
3 vehicles, lordship. An auto rickshaw was insured with the appellant insurance company. And lordship, we have examined defense witnesses. Here, FR we have exhibited, lordship. In the final report, it is clearly stated, lordship, that because of negligence driving of the rider of the motorcycle, the accident took place, lordship. And as such, FR was submitted and both the rider were expired in the accident, lordship. And one of the deceased, one of the rider of the motorcycle, lordship. And he was 16 years old at the time of accident. He had no license at all, lordship. So under such circumstance, lordship, the learned tribunal did not consider all these aspects of the matter.
Who is the claimant?
Claimant is the mother of the deceased, lordship. The son is 16 years old, lordship. Without considering these aspects, lordship awarded the compensation against the insurer of the lordship, this auto rickshaw, lordship, the appellant insurance company.
Third, Miss M. Chaudhary, the learned counsel for the appellant insurance company. Also, Mr. M. Khan, appearing for respondent number
One.
Respondent number 1,
I'm appealing for the respondent number 4.
as well as Mr. A. Kakoti, appearing for respondent number 4, as well as Miss Shom R. Saha, appearing for respondent number 3, and Miss D. Goswami, appearing for respondent number 5. Who is appearing for 2?
2 is not lordship. It is not yet.
Stop.
We have not taken steps, lordship.
This appeal under section 173 of the Motor Vehicles Act 1988 has been preferred by the appellant, namely Oriental Insurance Company Limited, impugning the judgment and award dated 19/12/2024, passed by the Motor Accident Claims Tribunal, Bongaigaon, in MAC case number 100/2017. Stop. Whereby the appellant was directed to pay a compensation amount of rupees 8,29,000 along with interest to the claimant/respondent number 1. Issue notice, since all the respondent except respondent number 2 have been represented by their engaged counsel, no formal steps are required to be taken for issuance of notice to the said respondent. However, the appellant shall furnish requisite. You have received all of it? Okay. A line continue. The appellant shall take steps for issuance of notice upon respondent number 2 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 7 September. Let the records of MSC case number 100/2017 be called for. Registry to take steps for requisitioning the records. Considering the grounds stated in the memo of appeal, this appeal is admitted. Let this matter be listed on 7th of September.
Must oblige, lordship. I was there.
You are pressing?
No, lordship. At this stage, notice may go, lordship.
All are lordship, this is a tactic, my friends, lordship. 50% lordship.
Why, lordship? All 3 vehicles are involved where there is no evidence, lordship. Why should we?
There is a clear evidence, lordship, the vehicle.
You
that
file
vehicle is-
objection.
Yes,
You
lordship.
file written objection.
They may file an execution case, lordship.
That might be
In
a
that
lordship,
case, lordship.
50%.
You are not pressing.
I pray before your lordship that I may be allowed to issue notice on owner. One more ground is that the driver who drove the vehicle, auto rickshaw, he had no valid driving license, lordship. That's why owner is.
Who is number 2?
Number 2 is the owner, lordship.
Okay.
Therefore, lordship.
You may file objection on the next day.
Well,
Taking your plea that 50% may be released.
At this stage, I am not paying.
Stay may not be granted, lordship.
Let the service.
I am not granting.
Yes.
In IA issue notice. Issue notice to steps for only respondent number 2, others are represented. Write the names of the counsel.
I'll serve the copy, lordship.
The applicant shall furnish copy of this interlocutory application to the learned counsel for the opposite parties within 2 days from the date of this order. The opposite parties may file their written objection to the same if they desire to do so on or before the next date fixed. List this matter on 7th of September.
Must oblige, lordship.
7th September. Third, Mr. R. Sharma, learned counsel for the appellant, This appeal under section 173 of the Motor Vehicles Act has been preferred by the Oriental Insurance Company Limited, impugning the judgment and award dated 28/1/2026, passed by the Motor Accident Claims Tribunal, Sonipote, Tejpur, in MAC case number 14/2021. I have gone through the grounds stated in the memo of appeal, as well as considered the submissions made by learned counsel for the appeal. This appeal is admitted. Let the notice be issued. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 7th of September. Let also the records of MAC case number 14/2021 be called for from the Motor Accident Claims Tribunal, Sony. The registry shall take steps for requisitioning the records. List this matter accordingly.
There is an IA.
Will issue notice now. IA issue notice. Given back here, see. Time is over.
Only 10 notice that enhancement.
Then issue notice. Same order होगा.
Enhancement notice for appeal mechanism admitted for LCR.
Appeal admitted, steps within 7 days by speed post and next date 7 September.
Item number 54.
And LCR also required also the LCR mechanism for
LCR.
Item number 54 was fixed for hearing in the part of IA.
Item number
54. For stay of the impugned judgment because appeal has been already admitted.
But we don't have time.
My lord, supposing, my lord, my learned friend want stay order. The first thing, my lord, execution has been partly done. The sale through court procedure has been completed. Now, your lordship, as your lordship knows, in terms of section 55(1) of the
No, it was fixed for hearing.
is fixed for hearing. So therefore, my lord, execution is over. Now, apart from that, my lord, there is should have been two sets of appeal. Decree was dismissed so far they are concerned. They have to file a separate appeal for that. And the counterclaim is allowed so far we are concerned.
So
The
they have
appeal is required for that purpose also.
So they have appeal against counterclaim.
They did not file it. They want to say that it is a joint appeal which is not maintained.
Joint appeal.
Is not maintained. There is a decision of this honorable court.
Yes, separate appeals have to be filed.
And if your lordship look at the prayer, they are saying only in regard to the suit, not in regard to the counterclaim. So therefore, that way also is not. If they want to press the suit only, then they are not. They cannot be asking for.
We'll fix it. Because today we don't have time. We'll fix a short date.
Possession may be delivered to them because.
Lord, as your lordship knows that if the sale deed has been already been executed through court's process, now the ultimate process delivery position is implicit. It is automatic, my lord.
Otherwise, my lord, my appeal may be infructuous.
That is
When is the date fixed?
Today itself.
Then it might have been
execution was fixed for report.
What happened today?
Till now, we have not received any instruction. We have submitted before the court that today is fixed for passing hearing on the IA.
Till now, we have for not. That purpose, they will have to show there is a strong prima facie case. They have no case. What happened, Melo, in this case? They did not lead any evidence. They did not cross-examine. They even did not participate in the final argument. Now, in the face of all
We'll
that,
fix it on Monday.
Monday,
my lord, I'll be out of station if you lordship.
Tuesday.
Can it be on?
Till then,
Look, till
till-
then business when comes.
We don't know what happened.
Till then business when comes, you'll have to satisfy your lordship first that there is a strong prima facie case. There is nothing, my lord. And in the meantime, execution partly has already been executed. My lord, I have that sale deed, my lord.
actually, my lord, what has happened, we have first filed an appeal before the district and session judge. Thereafter, it was reverted before this honorable court, and again, due to some mistake, it was again reverted back to the district and session court.
Oh, what land it is?
Therefore, we have
It
filed
is,
an
it is a plot of land having residential houses or an open land.
residential. Yeah.
So the,
My lord, your lordship kindly see the sale deed has already been executed on this 14/7.
no, whether somebody may have to be evicted for,
No, they, my lord, they will have to be evicted. There are 2 katha and 8 lectures of land. Now, if your lordship want to pass order, that appeal is not there before your lordships. And this is your lordship will find on 14/7 that has been executed already.
okay, we'll fix it tomorrow.
Yes, tomorrow is all.
Tomorrow we'll fix it. You, in the meanwhile, you take instruction.
Yes, sir.
What happened in the, due to paucity of time, heard Mr., what is the name?
C. Sharma.
Heard Mr. C. Sharma, learned counsel for the appellant. Also heard Mr. S. Datta, learned senior counsel assisted by Mr. S. Datta, learned counsel for the respondent. Due to paucity of time, this matter could not be taken up for hearing today. As such, let this matter be listed tomorrow, that is 30 July at 2 p.m.
Deeply obliged.
Obliged.